What's up, guys? Welcome to Lawsplaining the Interwebs. I am your early and hetero host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today, oh baby, we've got some showing to do. I've got a couple things for you. Two things came my way today. Two things. And the first one is juicy. It's that red meat. It's that red legal meat. That fully legal meat, not barely legal. This is aged prime beef. Aged prime juicy meat you want to sink your stinking teeth into because oh baby, it's good. This is what the channel's about. There's a deep dive into a case and we get to learn something. We get to learn something very funny about a case that's relevant to what we're talking about. In this case, defamation in Texas, in Tarrant County, in the Court of Appeals, about the TCPA, and we might just have a little bit of snickering to do during this case. But we have that to start. That's to start. And I mean, I am becoming quickly a hype man. And I don't like being a hype man. I'm not good at it, but I've got to hype this. This case is really, really on point and really, really important. And if you don't think that this case is going into to apply in Vic's case, well, I don't know what to tell you. So that's the first thing. So I get this and I review it and I'm like, oh baby, this is great. This is what I'm looking for. I got a show topic tonight. We're going to delve into this thing and then some little fuzzy green fruit sends me something I didn't believe existed. And I should have believed it existed. Of course it exists. It always exists. And do me a favor. When midnight comes and we start talking about it, and I'm barely going to even tease this. I want to give nothing away. Okay? So this is the only tease I'm going to give you. And I don't care how far we are in the other case. At midnight, we stop everything. Right at midnight. And I'll give you the cue and all I want to see in chat. And here's your only clue for what's coming. 59 minutes from right when I say this. You guys are behind a little bit, but 59 minutes. I will cue you up and all I want to see is the chat to light up with reset that fucking clock. So we will see, and this better be good. Oh guys, I don't hype. I tease a little bit here and there. I don't hype, but today I'm hyped. So I'm hoping to hype you. And if you hate me, hate me. I don't think you will, but tell me. So oh, still gross. Pepsi with mango. Foul invention. I'm out of tea. I'm going to be in a bad mood, but it's going to cheer up right at midnight. So that's 58 minutes from now. Let's cover a couple groundskeeping, whatever it is. And by the way, guys, trust me, by midnight, we want all all eyes on this stream. I want Kick Vic's eyes on this stream. I want Toye watching. I want Rial watching. I want Lemoyne watching. I want all the con sluts watching. Oh, I want everybody watching. So if you would, I don't ask this often, if you would like the video, please, and help kick it up that trending topic, because both sides need to see what happens at midnight. I could spend an hour hyping this, and I know some of you are going, oh God, he's going to spend an hour doing it. I'm not. But if my mods could help me out and just occasionally promote the stream, hit that like, slap that like, whatever you want to say, I don't care. Do that. Kick us up into trending, because trust me, everyone wants to see what's going on. And it's okay. So here we go. 56 minutes. What we're going to start with, though, is right here. This is the... Hold on. I'm not mad. I'm just disappointed. There we go. Here we go. Sorry. That was less dramatic than desired. It was supposed to be just there. Let me shrink this down just a hair. So we have it, we've got some size issues here. It's too big. It's too big, baby. Too big. So this is Vanderlyn versus Khan, November 9th, 2017. Caveat: this case has petitioned for review by the by the State Supreme Court of Texas. It has not been granted or denied cert yet. So this is right now controlling law in Tarrant County, and that is not going to change by September 9th. Okay? So tell me the autofocus. If that autofocus is going, I'm gonna annihilate something. No autofocus. I'm gonna kill a can of Pepsi. I'm bringing the DACA, buddy. I'm bringing the DACA. All right. So let's go. I'm gonna read a little bit of the introduction. Well, there's a couple really early chats, and I want to get those in. They came in 11 hours ago. So I want to make sure we hit those, and then we're going to go right back into it. So the background: businessman brought action against neighbor for defamation, tortious interference with contract, and tortious interference with prospective advantage/business relations based on social media messages that neighbors sent to businessman's alleged business partners, informing partners of businessman's alleged admission to providing financial support to a terrorist organization. Neighbor filed motion to dismiss under the Texas Citizens Participation Act. The 415th District Court, Parker County, number CV160633. Roy Graham Quinsbury III denied the motion, and the neighbor appealed. The Court of Appeals held that. Now, this is just the holdings of the case, but it's not necessarily the holdings. It's how they get there. Businessman failed to make a prima facie showing of the elements of tortious interference with contract. Businessman failed to make a prima facie showing of the elements of tortious interference with prospective business relations. Businessman's denial that he made the alleged statements established prima facie showings of falsity and negligence, supporting denial of neighbor's motion to dismiss defamation claims, and neighbor was entitled to award of costs and attorney's fees. Affidavit affirmed in part, reversed in part, and remanded. All right. Now, well, hello, Ty Beard. Yeah, listen to Ty Beard. He tells you. You will not be disappointed. Okay. I don't know. Let me read these quick. There are 4 preemptive chats, and we're going to hit those, and then we're going. Pie Baker says, Mr. Sabat, we are not friends and I don't like you. However, I suggest you take a sabbatical to go to, that was a pun, and go seek some counseling. Then in about a year, hire a PR firm, make a public apology. Then you'll be welcome back with open arms. Until then, hashtag kick Sabat. It'll work, right, Chris? It'll work. Don't worry. Everybody's got your back. We all believe that you'll come back. Pie Baker says, everyone in chat, if you are believed to be or have a loved one that is or believed to be on the autism spectrum and you are an anime, press 1 now. Funimation, you should be watching. We are customers. Sabat is losing you, and we are indeed watching. So you can participate. You can participate in that if you want. The Pie Baker says, Dear transcriber, Ron's a cuck, Ron's a cuck. Ron's a cuck, he's a cuck. Ron is a cuck, he's a massive cuck. Ron is a massive cuck. He bring all the snack trays to the steeds. P.S. Mars Girl, are you still paying a lawyer? So there you go. Someone just asked if Ty would want to join me for an analysis. I'm sure Mr. Beard would love to. We talked about it. He's actually got trial tomorrow. He is in trial tomorrow, so he will not be joining me for this analysis tonight. Interestingly, with 3 days to go to file the case, Ty is confident enough to not postpone a trial. So he's going to be spending an entire day, and he still doesn't seem too worried about getting everything done for Vic's stuff. So I trust that their team is moving swiftly. But he was not able to. He was not able to join me on the stream tonight. So Corono, I gotta credit you, but you sent this to me. But by the time you sent this to me, I had already seen it. But props to wherever you got it from. You're doing your research, my dude. Okay. Blaine20 says, for the record, I saw this coming, whatever it is. Also, be sure to save the tear-off coupon. When you turn in 2 scoops, you'll be considered a legitimate news source. And RZEQDW says, if Ty is in the chat, have you had the chance to read my email? I have a legal question I'm trying to get the answer to. I'm gonna guess it's probably no, but yeah, I know who you are, and I'll let him know to see if he or someone on his team can help you out with that. Okay, introduction. So let's start getting the intro and the background going here on this case. In 4 issues, appellant Catherine Vanderlinden brings this interlocutory appeal of the trial court's denial of her Chapter 27 motion to dismiss appellee Dr. Nadim Khan's lawsuit against her. We affirm in part and reverse in part the trial court's order and remand the case to the trial court for further proceedings. Background, the parties. Khan is a board-certified family practice physician who, after graduating from medical school in 1996, moved from Pakistan, as Obama would say, to the United States to complete his residency at John Peter Smith Hospital in Fort Worth. At the time the lawsuit was filed, Khan was the chief executive officer of Tri-Cities Urgent Care located in Willow Park, Texas. Vanderlinden is a retired colonel in the United States Air Force. Her 24 years of service in the USAF included a deployment to Iraq, where she served for 5 months in the trauma hospital at Balad Air Base. Vanderlinden and Khan were neighbors in Parker County, Texas, and Vanderlinden said that she and her husband considered Khan and his wife friends. Their children attended the same school, and at one point, Vanderlinden was one of Khan's medical patients. The initial controversy. Dum. Catch you later, Ty. Oh, hold on. Oh, my goodness. The initial controversy, according to Vanderlinden, one evening in July 2015, when she and her husband were having dinner in the Khan's home, she and Khan engaged in a private conversation in the kitchen about the United States military presence in the Middle East. According to Vanderlinden, during that discussion, Khan told her that he had given money to the Taliban. Vanderlinden described herself as shocked when Khan said this, and she immediately questioned Khan as to why he would do such a thing. Khan's explanation, according to Vanderlinden, was that his grandfather, who had worked with the CIA, had related to him how he had witnessed the United States flipping sides with different administrations. Khan denies that this conversation ever took place. In his affidavit, he further posited that, quote, "It defies logic that he would make such a radical statement to a former colonel of the United States Air Force." According to Vanderlinden, approximately 1 week later, she questioned Khan about why he would donate money to a terrorist organization. During that conversation, Vanderlinden said that she told him about a horrific mass rape event perpetrated by the Taliban upon every female in a village, from infant to elderly, the aftermath of which a friend of hers, who had also been deployed to Iraq, had witnessed and later told her about. In a reaction Vanderlinden described as odd, Khan allegedly responded to this story by saying the event was bad and that he really preferred animals over people. Come on now. According to Vanderlinden, he said if he passed an injured person on the side of the road versus a wounded animal, he'd rather stop for the animal. Khan also denies that this conversation ever took place, and in his affidavit, he pointed out that he had devoted his career and life to treating individuals as a medical doctor. I took that preferred animals over people way differently. Woo! Vanderlinden claimed that Khan's wife, Shannon, was present for this second conversation, but neither side offered Shannon's testimony into the record. According to Vanderlinden, these two conversations concerned her, especially given her military career in which she had, quote, seen firsthand the horror that terrorist organizations such as the Taliban have produced. Vanderlinden felt obligated to inform others of what Khan had told her because, in her opinion, Khan's statement that he had given money to the Taliban was a matter of public concern. No one disputes, however, that Vanderlinden waited more than 5 months to act on this sense of duty. Now, pause your little jets for just a minute and ignore the obvious stereotypes of a Pakistani American donating to a terrorist organization in the Middle East and saying something that vaguely sounds like he wants to bang animals, okay? Ignore that because that's all very sensational. Let's look real quick at the factual scenario we have. We have someone making absolutely outrageous claims about a set of facts that defy logic and reason. Khan has said it defies logic that he would make these comments. He knows she's a former colonel of the United States Air Force. So even if it's true, right? So even if it's true, he's saying, why in God's name would I even say it if it were true? Second, these statements seem particularly calibrated and calculated to cause the maximum amount of damage to a doctor of Pakistani descent, right? And she then took it upon herself. She felt the necessary need. It's redundant and I don't care. The necessary need to spread this horror out to all of the people who didn't know, but just had to wait 5 months to do it because, okay? She had to do it, but just had to wait. It's very, very imperative to get the message of this dangerous terrorist supporting animal banger out there in 5 months. Okay. Start putting the pieces together. What does this kind of sound like, right? Oh man, everybody's in danger from this man. Ridiculous circumstances all over the place. All of this stuff taking place in public. And then they wait like a decade to say anything. It's fine. It's fine. Everybody, all these con sluts are in danger, but they gotta wait a decade to tell anybody because. All right. So I just want to get that out there. Notice a fact pattern that's got some similarities, especially in theme. van der Linden's message in January 2016. Van der Linden sent the following message to the Facebook accounts of Khan's business associates, Beverly Murphy, Tim Murphy, and Loretta Sheldon Murphy via Facebook Messenger. You are partnering with a Muslim who has told me personally, not via hearsay, that he has given money to the Taliban. The fact that Shannon Khan is my neighbor has nothing to do with anything. That's weird. That's a weird statement. I was deployed to Iraq for 5 months at a trauma hospital at Ballard Air Force Base, or Ballard AB, and retired as a colonel in the U.S. Air Force. Anyone who gives money to the Taliban is my enemy. No lawyer you can hire will undo terrorist involvement. Good luck, Kathy van der Linden, Colonel, U.S. Air Force, retired. She received no response to the message. I'm going to need whiskey soon. The record is vague as to how van der Linden obtained the names of Khan's business associates. Van der Linden claims that she became aware that Khan had a potential business venture pending with relatives of a woman named Melissa Murphy Miller. According to van der Linden, by looking at the friends on Miller's Facebook page, she was able to identify the individuals, Beverly Murphy, Tim Murphy, and Loretta Sheldon Murphy, who she, quote, thought might be Miller's relatives. Khan provided a different explanation. In his affidavit, Khan claimed that he had come to learn that van der Linden and his by then estranged wife, Shannon, had placed spyware on his personal computer at his residence and accessed his personal email accounts. According to Khan, van der Linden had learned the identities of his business associates by gaining access to his computer and email accounts. In her supplemental affidavit, van der Linden neither elaborated on how she initially became aware that Khan had a potential business venture pending with relatives of a woman named Melissa Murphy Miller, nor denied that she had accessed Khan's personal computer, either individually or in concert with Shannon. But as to the allegation that she had placed spyware on Khan's computer, she swore that she had never placed spyware on Khan's computer and that she had no knowledge of any other person, including Shannon Khan, having placed spyware on his computer. As to her motives, van der Linden explained that she sent the message because of her, quote, concern for community well-being and safety. What's that sound like? And to inform Khan's associates about his claimed involvement with a terrorist organization and enemy of the United States. She also stated, you know where you go when someone tells you that they are donating to a terrorist organization. It's not their business partner. It's not the business partner you go to. You talk to the people who can fix that. Okay. She also stated that she believed that if the business deal went through, part of these people's money could contribute to killing members of our military in Pakistan and Afghanistan and possibly attacking other United States interests domestically and abroad. The aftermath. Sorry. I hop in a one says, I love you, Nick. Andrew Yang for president. Check out Andrew Yang's session with Joe Rogan after this bad day's reviving stream with Nick. There you go. The aftermath. According to Khan, at the time the message was sent, he had an oral agreement with Sheldon Murphy, wherein Khan would find a seller producer to sell crude oil and or other hydrocarbon products. The crude oil and or other hydrocarbon products would be provided by a third party. Sheldon Murphy and Khan would split the greater of 10 cents or 10% of the margin per each barrel of crude oil or other hydrocarbon products. And he was clearly going to get the oil from that other party, being the Taliban. I don't have enough whiskey to make fun of that song yet. Let's change that. Okay, in honor of the retired U.S. Air Force Colonel, we are drinking military special blended Scotch whiskey. I've heard it's great. I've heard this is good. This is going to make me feel fantastic. It's going to hit all of the appropriate notes. It's even got like an olive oil spout to pour. Oh, Lord. Let's smell this. It doesn't smell too acrid. It just smells like butt. Okay. Oh. Let's see. God, it smells terrible. It's delicious. Whew. Oh. Oh, it's not even harsh. It's actually delightfully smooth. It just tastes rancid. Oh my God. Okay, in furtherance of that agreement, Khan claims that he, quote, had found a seller producer to purchase 60,000 metric tons of crude oil and that he would have received approximately $30,000 as a commission from this transaction had the agreement gone forward. In addition, Khan said he was in the process of negotiating another agreement with Sheldon and Loretta Murphy to purchase a 50% interest in Wham LLC. According to Khan, Wham, an acronym for Wellhead Automation and Measurement, was a North Dakota company that specialized in gas flow measurement in the oil and natural gas industry. Khan said he had incurred $250,000 in attorney's fees in his attempt to consummate this agreement. Khan, you can't be paying $250,000 to consummate anything. And he attacked, unless you're consummating a con slut, and he attached to his response purported drafts of documents related to that agreement. Had this deal been completed, Khan expected it would have been lucrative. He estimated that his profits would have exceeded $500,000. According to Khan, in anticipation of this deal, he had already obtained $23.3 million in grants that would go to the company. But the deal did not go through. According to Khan, while he and Sheldon and Loretta Murphy were in the process of working out the finer details of the written agreement, Vander Linden sent the message to them. Khan said that right after Sheldon received Vander Linden's message, Sheldon called him and, in an excited manner, asked Khan, "What the fuck is going on?" According to Khan, Sheldon told him that he had just received Vander Linden's message and then stated he could not proceed with the plan. After Vander Linden sent the message, neither the oral agreement nor the pending Wham deal went forward. Khan sued Vander Linden for tortious interference with contract and with prospective advantage/business relations and for defamation/defamation per se, and sought damages and injunctive relief. Vander Linden sought dismissal of all claims under Chapter 27 after the trial court denied Vander Linden's motion to dismiss. After the trial court denied it, Vander Linden brought this interlocutory appeal in which she contends that Khan failed to meet his burden to establish a prima facie case on each element of his claims by clear and specific evidence. That stuff's gross. That stuff's gross. Elliot Joubert says, "How are you enjoying that Spurg card I issued today? Never in my life would I imagine seeing so many Spurgs spurging out over saying Spurg, which has nothing to do with legitimate Asperger's or autisms or whatever." These people, this is why it's the words. It's the words that drive them nuts. There's two types of people in this world. People that are offended by mere words, and then everyone else on the planet. The word is not the issue. It's the intent behind the word that matters. It's always the intent behind the word. Anyway. Blaine 20. I'm enjoying it very much. Blaine 20 says, also known as submarine mechanics engine cleaner. Yes. Yes. The Anti-SLAPP Statute, Civil Practice and Remedies Code, Chapter 27, the Texas Citizens Participation Act protects citizens from retaliatory lawsuits that seek to intimidate or silence them on matters of public concern, i.e. strategic lawsuits against public participation, commonly known as SLAPP suits, by providing a mechanism for summary disposition of such suits, citing in R.E. Lipsky. Often thrown around on Twitter these days by some very, very exceptional individuals, the statute's purpose is to identify and summarily dispose of lawsuits designed to chill First Amendment rights, but not to dismiss meritorious lawsuits. Summary disposition is achieved through the TCPA's provision for expedited dismissal of lawsuits. The statute permits a defendant within 60 days of service of the lawsuit to seek dismissal of the lawsuit by challenging the plaintiff to show prima facie evidence to support his claim. The movement is entitled to an expedited hearing and, if ultimately successful on the motion, an award of court costs, reasonable attorney's fees, and other expenses incurred in defending against the legal action. Dismissal under TCPA involves a two-step process. First, the defendant movement has the burden to show by a preponderance of the evidence that the plaintiff's claim is based on or relates to or is in response to, among other things, the movement's exercise of the right of free speech. If the movement satisfies this burden, when the burden shifts to the plaintiff respondent to establish by clear and specific evidence a prima facie case for each essential element of the claim in question. The clear and specific evidentiary standard may be satisfied by direct or circumstantial evidence. See Hand versus Hughley, explaining that the clear and specific standard neither imposes a heightened evidentiary burden. That's not true, because it imposes an evidentiary burden which is heightened from prima facie, but we see what they're saying, nor categorically rejects the use of circumstantial evidence when determining the plaintiff's prima facie case burden under the Act. But as the Supreme Court has directed us, such evidence must be provided with some degree of detail, citing Lipsky, requiring enough detail to show the factual basis for the plaintiff's claim. In the context of a defamation case, pleadings and evidence that establish the facts of when, where, and what was said, the defamatory nature of the statements, and how they damage the plaintiff should suffice to overcome a challenge under the TCPA. Do we hear that? Pleadings that establish the facts of when, where, and what was said, the defamatory nature of the statements, and how they damage the plaintiff should suffice to overcome a challenge. We are directed to construe the statute liberally to effectuate its purpose and intent fully. And we review de novo, a trial court's denial of a motion to dismiss under the TCPA. In our de novo review, we consider the pleadings and supporting and imposing affidavits stating the facts on which the liability or defense is based. And it is based. Ryan Mercado says, wait, guys, this case sounds familiar. Oh, wait, Law Twitter keeps citing that over and over again nonstop. Lipsky, right? You're talking about Lipsky, I assume. All right. Now we're going to start getting into the weeds. This is the discussion section. The first prong, right of free speech. I hope you guys are following along on this. This is about to get... This is a heavy explanation of the TCPA as this Court of Appeals applies it, as the lower courts in this district will apply it. Okay? In her first issue, Vander Linden argues that she met her burden in the first step of the process by showing that the TCPA applies to Khan's underlying lawsuit against her. Khan's response is twofold. First, he argues that because the policy reasons underlying the TCPA are not present in this case, TCPA does not protect Vander Linden's message. Second, he argues that Vander Linden has not met her burden to show that the message was an exercise of the right to free speech, as that term is defined by the TCPA. Thus, Khan contends that because his lawsuit was not based on Vander Linden's exercise of her right to free speech, Vander Linden failed to establish that she was entitled to file a motion to dismiss. It's a losing argument, but Law Twitter has been citing Vander Linden? I mean, I hope they read it. I hope they read it. Khan maintains that the underlying policy of the TCPA requires us to make one ultimate determination: whether Khan's lawsuit was brought to chill van der Linden's First Amendment rights, or rather to bring a meritorious cause of action against van der Linden. Uh-oh. That's the first problem. He suggests that if we determine that the lawsuit was not brought to chill van der Linden's First Amendment rights, but was instead brought to assert meritorious complaints against her, then she is not entitled to seek dismissal under the TCPA. Khan contends that because he did not bring this action because van der Linden exercised her right to speech, but instead solely because she intentionally interfered with Khan's business deals, that she has not met the first prong of the test. We disagree. While our goal in applying any statute is to ascertain and effectuate the legislature's intent, Supreme Court instructs us that the source for legislative intent is found wherever possible in the plain language of the statute itself. When the statute's words, quote, yield a single inescapable interpretation, our inquiry ends. Section 27.003 provides that if a legal action is based on, relates to, or is in response to a party's exercise of the rights of free speech, that party may file a motion to dismiss the action. The question then is not whether Khan brought this lawsuit for the purpose of chilling van der Linden's First Amendment rights. The question is whether Khan's lawsuit is based on, relates to, or is in response to van der Linden's exercise of a right of free speech. I'm saying Linden. I'm just talking fast. Oh, God. Exercise of the right of free speech is defined as a communication made in connection with a matter of public concern. A matter of public concern is defined as, among other things, an issue related to health or safety or environmental, economic, or community well-being. And the TCPA applies to both public and private communication. Thus, under this statutory framework, if the message was made in connection with an issue related to health or safety or community well-being, it would fall squarely within the statute. For reasons so obvious that further elaboration should not be necessary, financial support for a terrorist organization is an issue related to safety and community well-being. Consequently, issues related to this topic are matters of public concern, as defined by the TCPA. Since van der Linden's message was made in connection with a matter of public concern, it constituted an exercise of the right to free speech, and as that term is defined in the statute. Public policy or legislative intent notwithstanding, our inquiry ends there. Because we hold that that the message was a communication made in the exercise of the right of free speech as defined by the TCPA, we sustain van der Linden's first issue. Now, important points that will come into play later in our analysis, and I think maybe some people are really missing. Actually, I know they're missing it. I know they are because I've read what they've said about this stuff, and they're stupid. So, this involves a matter of public concern. They have asserted over and over that Vic's case involves a matter of public concern. Why is that important? Stay tuned for the defamation section. The tortious interference sections are going to come and go in just a minute. They're not where I'm focused. The defamation section is what really matters. But pay attention on what happens with a case that's a matter of public concern involving free speech. A very important step goes away. We'll get there. We'll get there. The second prong, clear and specific. Because we hold the message, we sustain the first issue. The second prong, clear and specific evidence. Because van der Linden demonstrated that Khan's lawsuit implicated her exercise of the right of free speech to prevent dismissal of the action, the burden shifted to Khan to prove by clear and specific evidence a prima facie case for each essential element of his claims against her. Providing that the court shall dismiss the action if the movement shows that the action relates to the exercise of the right of free speech. Providing that the court may not dismiss the action if the opponent establishes by clear and specific evidence a prima facie case for each essential element of the claim in question. In her second issue, van der Linden argues that Khan failed to meet his burden of establishing by clear and specific evidence a prima facie case for each essential element of his alleged claims against her for tortious interference with contract, tortious interference with prospective business relations, and defamation/defamation per se. We take each cause of action in turn. To prevail on his tortious interference with contract action against van der Linden, Khan must prove that he had a valid contract with Sheldon Murphy. Van der Linden willfully and intentionally interfered with that contract. Van der Linden's interference proximately caused Khan's injury, and Khan incurred actual damage or loss. Thus, to prevent dismissal of the tortious interference with contract action, Khan was required to prove by clear and specific evidence a prima facie case for each of these 4 elements. On appeal, van der Linden does not challenge Khan's proof of willful and intentional interference. No clear and specific evidence of a valid contract. With regard to the existence of a valid contract, Khan testified as follows. Prior to van der Linden's message to my business partner, I had entered into a verbal agreement with Sheldon Murphy and was working on finalizing, failed, right there. Another agreement with Sheldon Murphy. Well, okay, so that's the second one. The first agreement that I had with Sheldon Murphy was an agreement wherein I would find a seller producer to sell crude oil and other hydrocarbon products. Crude oil and or other hydrocarbon products would be provided by a third party, Sheldon Murphy, and I would split the greater of 10 cents or 10% of the margin per each barrel of crude oil or other hydrocarbon products. I had found a seller producer to purchase 60,000 metric tons of crude oil, and my commission would have been approximately $30,000. Van der Linden cites Sarah Fine versus Blunt to argue this evidence is too vague and conclusory to support a prima facie case that a valid contract existed between Khan and Sheldon. In that case, Sarah Fine sued the Blunts after the Blunts took down a chain link fence that separated their properties, erected a new fence, and installed a drainage system that allegedly affected her property's lateral support. The Blunts counterclaimed for tortious interference with their contract with the drainage and foundation company. Among other things, Sarah Fine sought dismissal under Chapter 27. With regard to the contract at issue, the Blunts generally asserted that they, quote, had a valid contract with drainage and foundation company to install pump and drain system on their property. Specifically, they provided an affidavit testimony that Alexander Blunt, quote, hired Austin Drainage and Landscape Development to professionally install a pump and drain system. And at the hearing on the motion to dismiss, the trial court heard additional testimony from Alexander that Austin Drainage was going to install French drains around the property and against the border of his house that would tie into a sump pump that would pump the water out to a pop-out valve so it would flow down the street. Let's see. So here we go. They have clear and specific evidence of a contract in the Sarah Fine case because he's talked about under oath in an affidavit and then in testimony, apparently, right? It says the trial court heard additional testimony. So both in affidavit and under testimony, the guy said, I had a contract with that company to do this thing. I had it. I had the contract. Here's what they were going to do. Court held that while Alexander's statements indicate a possible contract, he failed to provide detail about the specific terms of the contract or attach to his affidavit any contract or other document memorializing any agreement between the Blunts and the drainage company about the scope of work to be done. Thus, the court concluded Alexander's testimony was not clear and specific enough to support a rational inference that a valid contract existed between the parties. We agree with our sister court's approach in Sarah Fine applying those principles here. Absent from the record is any evidence of what obligation Sheldon undertook pursuant to the verbal agreement that Khan described. Aside from Khan's unilateral labeling of it as a verbal agreement, whatever type of business arrangement Khan had with Sheldon is unclear in this record. For our purposes here, however, Khan failed to offer any proof, clear, specific, or otherwise, that it constituted a valid contract. Distinguish this from Vic's case, okay? Vic's case, he's asserted that he's had contracts with these companies. They haven't produced the contracts. I don't know if they will or not, but either way, Vic can show exactly what he was expected to do at each of the conventions. He was expected to show up. He had been announced. There were specific dates. He can probably tell you the minimum amount that he would do. His duties would involve meeting and signing autographs for people. The burden that the other party would undertake would be the advertising and announcement that they did not have to do. So there's an easy way to distinguish these two cases with Vic's case, where he can say, look, I was announced here, here, and here. I was announced so hard that they had to unannounce me. That's how clear it was that we had a contract. They had to specifically say, no, you're not coming. Pretty easy to show that a higher standard of or a higher amount of evidence than what was provided by these two parties in Vic's case. So we want to point out the distinguishing factors between Vic's TI claim and their TI claim. No clear and specific evidence of a breach. Without any evidence of the obligation Sheldon undertook pursuant to his verbal agreement with Khan, be no evidence that Sheldon failed to perform his obligations under the contract, i.e. that Sheldon breached the contract. Even assuming that Khan and Sheldon had an oral contract, we have held with regard to tortious interference with contract claims that to withstand a no evidence summary judgment challenge, a plaintiff must produce evidence of some obligatory provision of a contract that has been breached. Pretty simple. I'm supposed to come to the con I'm supposed to show up to the con. Con says no. They actually announced specifically that I'm not coming. Breach. Done. Period. That's simple. Again, easy to show. And all of this can be shown in an affidavit from Vic. They don't even need the con's help on this. But plus, of course, if they can show an actual contract, that's even better. While Khan states generally that after Van der Linden sent the message, Sheldon decided not to operate under that agreement, did not want to do business with Khan, would not go forward with that plan, and stated he could not proceed with that plan, the statements do not evidence a breach of contract. At best, these statements provide evidence that a business deal between Khan and Sheldon did not go forward, but they provide no evidence that Sheldon breached an oral contract. Thus, these statements fall short of demonstrating by clear and specific evidence that Sheldon's action or inaction constitute a breach of any contractual obligation. Now, there's another way to help out with breach. One way to help fill out the element of breach is to show what things the plaintiff, what burden the plaintiff undertook as well in regards to the promises made between the two parties. I took on this convention, which also meant I could not take on any other convention in that time. So there may have been conventions. I know there were some conventions where Vic was double booked or would have had to be double booked. So he would have had to turn down one convention to accept the one that eventually canceled him. So that's another way to help out with the breach element. And again, swearing to that stuff under oath is kind of how you do this, right? Unless you have a piece of paper. Andrew War Snowboard says, I saw Weird Al tonight, and when he said, I know Darth Vader's really got you annoyed, but remember, if you kill him, then you'll be unemployed. Oh my Yoda. I thought of the SPLC because of you. He was lit fire 100. Weird Al puts on a good show. He really does. All right. 15 minutes, y'all. 15 minutes. No clear and specific evidence of proximate cause. As part of her second issue, Van der Linden complains that the trial court erred by overruling her objections to Khan's evidence and challenges whether Khan produced clear and specific evidence that the message proximately caused Sheldon to breach his contractual obligations with Khan. Objections. Khan submitted 2 affidavits in response to Van der Linden's motion to dismiss. The second affidavit incorporated the first by reference. As to proximate cause, Khan testified as follows. After Van der Linden published the false and defamatory statements with malice to Sheldon Murphy as admitted in her affidavit, Sheldon Murphy decided not to operate under that agreement, and the sale fell through. I did not receive any commission as a result, and Sheldon Murphy does not want to do business with me because of the statements at issue. Again, we can distinguish this because Ron Toye and Chris, the owner of Kamea-Con, had an actual back and forth, and there was acknowledgement that these statements had impact on the decision. The statements and the information contained in the statements had impact on the decision to not bring Vic. We have actual evidence of that in Ron's text to Kamea-Con and Kamea-Con's text back. So there's that aspect of it. Next, Mr. Murphy explained to me that he would not go forward with the transaction immediately after reading the false statement published by the defendant. Mr. Murphy said he would not go forward with that plan. I know of no other factor that contributed to his decision not to go forward with the transaction. That's not clear and specific evidence, right? That's not clear and specific evidence because that doesn't actually provide evidence. That provides an inference. Now, circumstantial evidences involve inference, but there's nothing specific that he says, I read this message. Well, I guess kind of. There was kind of something, but there's nothing. It's lacking a little oomph here is what the court's saying. And I received a telephone call from Sheldon Murphy, who in an excited manner exclaimed to me that what the F is going on? Mr. Murphy stated he had just received the false and defamatory statement, then stated that he could not proceed with the plan. With regard to the first paragraph recited above, Van der Linden specifically objected to the statements. Sheldon Murphy decided not to operate that agreement and the sale fell through, and Sheldon Murphy does not want to do business with me because of the statements at issue. As hearsay and inadmissible speculation by Khan about the state of mind of another. Van der Linden posed those same objections to the second paragraph recited above. With regard to the last paragraph, Van der Linden objected that the entire paragraph is hearsay. At the hearing on the motion to dismiss, the trial court summarily overruled all hearsay objections. And when Van der Linden's counsel asked to be heard on his additional non-hearsay objections, including the speculation objections, the court replied, they're overruled. We start with fundamental premise that a witness's testimony regarding what another person was thinking is inadmissible speculation that should not be considered. Why on earth would Ty be trying to strike things for hearsay and speculation? Why? Why is that? I don't know. Khan's statements that Sheldon Murphy does not want to do business with me because the statement's at issue, and I know of no other factor that contributed to his decision not to go forward with the transaction, were offered to prove that what Sheldon was thinking or not thinking when he decided not to go forward with the alleged contract. These statements constituted inadmissible speculation. The trial court abused its discretion by admitting them over Van der Linden's objections, and we will not consider them as competent evidence for the record to defeat Van der Linden's motion to dismiss. Remember that really smart Texas attorney who was saying, why would you try and strike any of this as hearsay? Why would you want to do that? Well, I don't know. 11 minutes. As to the hearsay objections to the statement, Sheldon Murphy decided not to operate under the agreement and the sale fell through. Mr. Murphy explained to me that he would not go forward with the transaction immediately after reading the false statement published by the defendant, and Mr. Murphy said he would not go forward with that plan. These statements would fall within the operative facts exception to the hearsay bar. The fact that words were uttered is sometimes the fact to be established. Such testimony is received because the mere utterance of the word has legal significance. Observing a dispute between employment agency and employer, employment statement that he was leaving the company and did not want to work there anymore was admissible as evidence of operative fact of voluntary termination to prove that agency owed employer a refund fee for fee paid under the contract. Thus, to the extent that these statements were offered to prove that Sheldon refused to go forward with a contract with Khan, these statements would be admissible to prove the operative fact of the breach of contract. Whether these statements may be used as proof that Sheldon's decision to breach the alleged contract was proximately caused by Van der Linden's message is a separate question, which will be discussed later. As to the paragraph stating, I received a telephone call from Sheldon Murphy, who, in an excited manner, exclaimed to me, "What the F is going on?" Mr. Murphy stated that he had just received false and defamatory statement, and then stated he could not proceed with the plan. At least the first sentence of the paragraph would appear to fall within the excited utterance exception to the hearsay bar. Whether Sheldon was still in an excited state when he made the second statement is unclear, but for purposes of our analysis, it does not matter, as set out below. This stuff is gross. Gross! Huh. To prevail on the causation, probably going to get through this section and then it's going to be time. To prevail in the prima facie showing of his tortious interference with contract claim, Khan had to show that Van der Linden took an active part in inducing Sheldon to breach his obligations under a contract with Khan, such that her tortious conduct proximately caused his damages. Proximate cause consists of two elements, cause in fact and foreseeability. Cause in fact meaning that the defendant's act or omission was a substantial factor in bringing about the injury, which would not otherwise have occurred, cannot be established by mere conjecture, guess, or speculation. Holding that failure to hire a security guard, obtain police reports related to criminal activity in the area, or obtain required documents, social security cards, driver's license, and criminal background checks of tenants in an apartment complex constituted no evidence of proximate cause of sexual assault by a tenant. And also, holding that a jury cannot reasonably infer that defamation causes business cancellations when the cancellations could have occurred for any number of reasons, particularly since appellee never asked the customers why they canceled their business with his company. When the inadmissible speculation is removed from the evidence, the remaining evidence before the court on the issue of whether Van der Linden's message induced Sheldon to breach a contract obligation with Khan is Khan's testimony that 1. After Van der Linden published the false and defamatory statements with malice to Sheldon Murphy, as admitted in her affidavit, Sheldon Murphy decided not to operate under the agreement and the sale fell through. I did not receive any commission as a result. Mr. Murphy explained to me that he would not go forward with the transaction immediately after reading that false statement published by the defendant. Mr. Murphy said he would not go forward with the plan. I received a telephone call from Sheldon Murphy, who in an excited manner exclaimed to me, "What the F is going on?" Mr. Murphy stated he had just received the false and defamatory statement and then stated that he could not proceed with the plan. In examining the testimony that remains, notably absent is any direct evidence that the message is what induced Sheldon to breach the contract. At most, Kahn proved that the message and the breach occurred in very close temporal proximity to one another, but from this evidence, the trial court was left to speculate as to whether the timing of these events was a coincidence or whether a cause and effect relationship existed between them. This is poor pleading and poor drafting of your affidavits. That's what killed this case. Given the temporal proximity between the message and Sheldon's decision not to go forward with the contract, one might suspect that the message factored into Sheldon's decision. But just as conjecture, guess, or speculation will not survive a proximate cause sufficiency challenge in the summary judgment context, conjecture, guess, or speculation cannot survive clear and specific scrutiny under Chapter 27. Holding in a tortious interference with contract case that an environmental organization's claim of victory over wastewater contracts, termination, and online postings, when considered with other evidence, met clear and specific evidence standard for proximate cause within the meaning of Civil Practice and Remedies Code, Section 27.005B. Kahn did not offer affidavit testimony from Sheldon, the one person who personally knew why he refused to go forward with the alleged contract. So once the impermissibly speculative evidence from Kahn's affidavits is disregarded, there's simply no evidence, let alone clear and specific evidence, that but for the message, any contract between Kahn and Sheldon would have gone forward. Because Kahn failed to meet his burden of producing clear and specific evidence of a prima facie case for each of the above essential elements of his tortious interference with the contract claim, the trial court erred by denying Vander Linden's Chapter 27 motion to dismiss as this claim. We sustain this part of Vander Linden's second issue. TI with prospective business relations. Kahn contends that Vander Linden interfered with his verbal agreement to purchase Sheldon and Loretta Murphy's interest in Wham! LLC, a deal that, according to Kahn, was in the final stage of negotiations. Prima facie case of his tortious interference with prospective business relations claim against Vander Linden would show a reasonable probability that Kahn and the Murphys would have entered into a contractual relationship, that an independently tortious or wrongful act by Vander Linden prevented the relationship from occurring, and that Vander Linden did the act with a conscious desire to prevent the relationship from occurring, or knew that the interference was certain or substantially certain to occur as a result of the conduct, and 4, that Kahn incurred actual harm or damage as a result of Vander Linden's interference. Vander Linden did not challenge the third element, addressing her conscious desire or knowledge in her motion to dismiss, and she does not raise that ground on appeal. Yeah, she's like, of course I wanted to interfere with it, right? Reborn exists as Pepsi Mango is disgusting, but Kick Vic is going to be so incredibly salty after tonight, they will not know what to do with themselves as per usual. Keep up the great work, Nick, and thank you. Hey, buddy, thank you. Thank you. No clear and specific evidence that a relationship would have occurred or that Vander Linden's act prevented that relationship from occurring. Assuming without holding that the record contains clear and specific evidence of a reasonable probability that Kahn and the Murphys would have entered into a contractual relationship, the record nevertheless remains silent as to whether Vander Linden's conduct prevented any prospective business relations between Kahn and the Murphys from going forward. As set forth above, once the impermissibly speculative evidence in Kahn's affidavit is disregarded, all that remains is evidence of a temporal proximity between the message and the breakdown in negotiations between Kahn and Sheldon Murphy. There's no evidence in this record, let alone clear and specific evidence, that but for, what's a but for? The message, a reasonable probability existed that the prospective deal between Kahn and the Murphys would have gone forward. Compare COC Services Limited. Construing the element prevented the relationship from occurring to require that the tortious conduct constitute a cause in fact or but for causation. And Gonzalez versus Gutierrez, limiting recoverability of damages to those sustained as a natural and proximate consequence of the interference, finding no evidence that but for the interference, plaintiff would have been awarded a specific contract bid or lease. And Hill versus Heritage, stating that while it is not necessary to prove that the contract would have certainly been made, but for the interference, it must be reasonably probable considering all the facts and circumstances attendant to the transaction. And Exxon Corp versus Alsop, which says the same. 3 minutes. How much? Oh, we going to get it? I don't know if we're going to get it. No clear and specific evidence of actual harm or damage in his affidavits. Khan provided various estimates of what he would have earned had the WHAM agreement with the Murphys been consummated. He stated both that his projected income from the WHAM purchase was set to be $500,000 annually and that the profits would be far more than $500,000. In his supplemental affidavit, he stated that after studying the project and its potential for profit, in his opinion, based on his extreme experience and education, he would have made a substantial profit from that project, certainly more than $1 million. Although Khan's statements may constitute some evidence that he suffered harm or damage as a result of the failure of the WHAM transaction to go forward, these statements are not sufficient to establish a prima facie case of actual harm or damage under the TCPA. Supreme Court has instructed us that general averments of direct economic losses and lost profits, even when a dollar amount is specified, do not satisfy the minimum requirements of the TCPA. More than mere recitation of estimated damages is required. Okay, I'm going to pause here. I got 2 minutes. 2 minutes. Because I want to address something. We're going to resume right here. First of all, after this next section, do not leave. Do not leave just because this next section is done. The next section is the big thing, and it's coming. But don't leave, because we're right here on the defamation part, and this is the most important part of the suit. And this is something that I swear no one's reading, apparently. So we're going to talk about that section. We're going to talk about that section in a minute. Next thing, got 1 minute left. GoFundMe. I announced that I was going to announce the GoFundMe plans for these Vic prints. I have to put that on pause. Because I have to get some input from GoFundMe, because they're being cuckbags on the campaign, and I'm not going to risk the campaign over them misconstruing what's going on. So I have to get confirmation. I have tried to get confirmation, but their promotions team sucks at getting back to me. So I'm going to reach out to my personal liaison with GoFundMe, and I'm going to find out a definitive answer, not a weasel answer that they gave me before, and I will announce it as soon as possible. So I apologize for that. It is midnight, y'all. It is midnight. Reset that fucking clock. Here it comes. I've got something for you. Talenseer says Ron Toye is a weird, genderless species of vermin. Obviously, were he in prison, he'd be thrown about like a dog toy. How appropriate. Here we go. What is this? In the matter of the marriage of Redacted and Ronald J. Toye III. Uh-oh. Would this be the affidavit of the ex-wife of Ronald Toye in their divorce, in which she is begging the court to impose a restraining order against the abusive monster that is Ron Toye? Every fucking time with these male feminist beta weasels. Every single time. Every fucking time. Run out champion of women. What do they do the moment they have power over a woman? They beat them. They scare them. They threaten them. Every single time. Toye is no different. If you're watching, Kick Vic, and I know you fucking pussies are, you're watching, pay attention. This is the piece of shit scumbag degenerate that you're jerking off every single day. Listen to what he did. And oh, wouldn't it be embarrassing if a court held that these facts were true after a hearing? Oh my God, wouldn't that be embarrassing? Guess what? You won't find out if they did or not today, but you probably will tomorrow, won't you? Won't you? So a shout out, a personal shout out to someone who on their own initiative, without my request, sent this to me. And before you idiots on KickVic say, oh, he got these from Ty. No, I did not. I did not get these from Ty. But guess what I did the first thing after I read them? I sent them to him immediately. Immediately. And have fun filleting this sack of woman-beating shit. And I can say it all day. All day. Sue me, Ron. Sue me. I fucking mean it. You want to deny it's true, Ron? And all you women championing idiots out on the KickVic side have no regard for actual women. Not a single shred of it. Not a single shred of it. You're out there pontificating. And here you are. Here you are gargling the soy milk coming out of Ron Toye's mammaries. Well, let's see what he said. What happened, right? Let's see what happened. I've redacted the names of Ron Toye's ex-wife. I've redacted the name of Ron Toye's son. I've redacted any other names that are specific in this. Just left Ron. Just left Ron. Blank appeared in person before me today and stated under oath, my name is redacted. I am above the age of 18 years and I am fully competent to make this affidavit. The facts stated in this affidavit are within my personal knowledge and are true and correct. I'm the petitioner in this case, aka Ron's ex-wife, his second ex-wife. Because he had a first ex-wife. You're going to learn about how he treated his first ex-wife just a little bit in this affidavit as well. So it's not an isolated incident, is it, Ron? Is it? Why do you use all those emojis, Ron? And for every sack of garbage out there that says that I am somehow a danger to my wife and children, you will never, ever see even a complaint of domestic abuse from me. Not once. But one of the guys you're supporting, court found it true. Think on that. You don't support me. You think that I'm some monster because I say mean words to your little idols? These are your idols. These are the people you're holding on such a high pedestal. Think about it. Think about why he uses all these emojis. In the beginning of our relationship, Ron was a perfect gentleman. Hey, Monica, is this true for you too? By the way, think about Monica in this. We might be wrong on Monica. There's been some speculation out there that Monica is actually acting out of fear. Monica, if that's true, ditch him. Ditch him immediately. Get yourself out of this. If you were pressured into this by Ron, if Ron put the fear of violence into you, if Ron shamed you, if Ron hurt you, I will apologize for everything I've ever said about you publicly and immediately. I will apologize for everything. And I bet you get out of this lawsuit in a heartbeat if you just admit that that's what happened. I don't know if that's what happened, but Monica, if you're out there and this sack of garbage is beating you or scaring you or threatening your friends, your family, your animals, whatever it is, you don't have to put up with that. You don't have to be dragged into a lawsuit. Especially if you know who Vic is. And I think you do. I think you know. Ron was a perfect gentleman. He had my family, friends, and me fooled. Slowly, he began to show his anger, control, and manipulation problems. This year, his problems have come to a climax. I become scared of his personality and the things of which he is capable of doing. On March 31st, 2012, Ron's son, and I were sitting on the couch in the living room. I was working on homework and Ron was tickling/wrestling with his son and kept causing his son to kick me in the back. I asked nicely if they would stop doing that and that he was hurting me. But Ron continued doing what he was doing. When I got kicked again, I asked again if he would stop making his son kick me in the back. When this happened a third time, I had the remote in my hand, reached across to tap him with it to get his attention to stop. He says I purposely hit him in the funny bone. Really, Ron? After this, he lost his temper on me in front of his son. He took the remote away from me and stood up above me sitting on the couch. He then said, and pardon my English, but it's Ron's, "You tell me how this fucking feels." Then from above me reared back and hit me with the remote. Even though the instances of physical abuse are small, his emotional abuse has been extremely continuous. He has cussed me out, called me names, charged at me, and threatened me and my family, and has even done some of these things in front of his son. He has threatened me with my life, our money, our home, and my dogs. Pretty much anything he knows that I love or rely on, he has threatened me with. One of the voicemails I have saved shows exactly this bullying and threatening nature. I have it saved in my email under July 2nd, 2012. Quote, Ron Toye. "If I were you, I would call me back pretty fucking quick, because I told you about hanging up on me, okay? It's not like you do a lot, or you do have to do a lot, seeing as you are afforded the opportunity to stay fucking home. So if I need you to come get me, guess what that means? You fucking come and get me. Otherwise, I will take your car and you can fucking hitchhike and figure out how to get around, because I pay all the fucking bills. I don't like being hung up on. You don't like fights? Don't do stuff to provoke me. You know you fucking provoke me when you hang up on me, okay? I didn't ask you to do anything for your mom. Your mom has another daughter who lives with her named redacted, who can pick her ass up. I don't give a shit about your sister. I need to get something taken care of. Don't fucking hang up on me again or you can fucking walk around." Look at that. Look at that. Now I'll tell you something, guys. You don't put a quote like that in an affidavit. You don't put a quote like that in an affidavit for a protective order unless you're damn sure ready to play that clip in court. You better be ready to play that clip in court. How disgusting. On October 15th, before he was served from his ex-wife, and the same day I decided to have lunch with my dad about my decision to divorce Ron, his angry attentions were on me. He was upset about something, and when I refused to answer the phone at school, he left me a voicemail in which he stated, redacted, "Unless you truly want a divorce, you need to answer the phone. I'm being more than lenient. I'm just trying to talk this thing out, considering what you fucking did. And if you think poor you, how about I chop your fucking dogs up and see how you like it?" Let that sink in, Kick Vic. Have fun. Have fun supporting this monstrous lunatic. He's gonna chop her dogs up? It gets worse. It gets worse. Later that day, he was served a protection order from his ex-wife and a suit to modify parent-child relationship. He was livid. When I got home, I saw that he had kicked a hole completely through one of our walls, picture attached. He had mentioned something on the phone about killing her, so I decided to start recording after I got home. He shows what his intentions are when people get in his way. At 7 minutes, 10 seconds, Ron, if somehow, because I understand that if somehow, the judge better hope not, he doesn't have kids either, because I will fucking, it's seriously, if something comes through with my son, is my anchor to sanity. If something happens there, it's going to be very bad for a lot of people like the judge, redacted, and his family. Everyone. Everyone. It's going to kill a judge? Going to kill a family of the judge, his judge's kids? It's going to kill the family of, I think the second redacted name here is his first ex-wife's new husband, I think, or boyfriend. I don't know. I've just got a first name. But that's in context. That's what kind of makes sense, because it's his first wife and then a male name. And I don't know who that is. but apparently Ron's gonna kill his family. I'm extremely concerned with the timing of my decision to divorce Ron. He has already made it clear to me that he is an extremely angry and violent nature, and now with his son's custody involved, I am frightened my decision will affect him even worse. I have to get out of this marriage. I'm overwhelmed from constantly being harassed and threatened. I am terrified that he will see my decision and do things to harm my family, me, my dogs, and our residents. I would like a protection order keeping him from me, my place of residence, any place of employment I may have, and my school premises of Texas Christian University. I would also like it added that he cannot contact or come in proximity with any of my family members for fear of his outlash. In addition, due to his manipulative nature and threats prior of ruining my life, I would like him restrained from making any disparaging remarks about me in public or to people not involved in the case. I'm scared that he's going to attack me in one way or another, whether it is with violence, manipulation, or a hired hand. The residence located at Redacted, where we have been living, belongs to my family, and Ron has no ownership interest in the property. I live there under a lease that Ron is not a party to. AWIG, it's not the ex-wife's lawyer. I don't believe. Now, I have in my possession a lot of documents about this divorce. I think we may be going through them soon to learn what kind of guy Ron is. But I've got a lot of redaction to do. Obviously, I don't want any impact on any of these other people. Let me read the chats, and then I've got some closing thoughts on this. And I told you guys, this is I told you, I don't hype things. This is legitimate nuts, an insane, degenerate, woman-beating person, threatening, manipulative, conniving pile of garbage. Okay. All right, let me read a couple of these chats. Tucker says, oh boy, here we go. Morty J says, midnight hits, from whom the bell tolls. Say it with me, rackets. Good morning, Vietnam! Kilo Bravo 777 says, well, seems like we got a beta wolf and a sheepdog skin. Tucker says, this piece of soy-filled shit reproduced. Oh my god, this is so bad. Zero the Slayer says, dude, this is bringing a whole new light to him wearing what he did to the other depositions. I know, I joked about the wife beater, right? I joked about him wearing it. Like, I don't even want to make jokes, because I have really funny jokes to make about this, right? I have, not this, about Ron and Monica and that whole thing. And now I'm like just too appalled and disgusted at this. Matthew Lemons, why'd this have to wait until midnight? Because it's when the maximum amount of people would have filtered in. That's why. I want as many people to see this as possible. As possible. I want people to know. I want people to know, right? Ron hasn't mentioned this publicly. As far as I know, Ron's never said, I had my troubles with women in the past. I got therapy. I apologize for it. None of it. None of it. Why not? Why not? This guy's talking about hugs in public. He's talking about a kiss with his former... What? Riddle me this. Maybe Monica's story is actually, maybe the truth of Monica's story is actually something like this. I went to Vic's hotel room. We'd had a couple drinks. We thought, maybe we'll make out a little bit. You know, see where this goes. They start kissing. Things are awkward. They've been friends for a while. They're coworkers. They say, it's not there. And then they agree to let it go. Then they go to dinner with Stan Dolan. Then they go back to Vic's room because literally nothing happened. What sounds more plausible to you? Monica's version of the story that she's sworn to in her affidavit that says that Vic forced himself upon her, pinned her down, kissed her. She was frozen and paralyzed. Then Stan Dolan valiantly rescues her, and they go to dinner, and then she goes back to his room to sit on his balcony to call his ex-wife, or to call his fiance that he apparently just cheated on. Which one of those sounds... And then she waits a decade to tell about the horror of that night. Or maybe, just maybe, there was a consensual interaction, didn't go anywhere. When Ron Toye found out about it, he flipped the fuck out. And Monica was scared because either she knows about this or maybe worse, maybe she doesn't. And Monica, if you're hearing it from me, I am so sorry that you have to hear this from someone you hate. I'm so sorry for that, if you had to hear it from me. But either Monica knows how terrifying and dangerous this little manlet is. He's 5'9", by the way. Or maybe she saw it on his face. And in the moment she said, Vic, kiss me, his eyes flashed with anger, and she got scared of what he would do to her. So she shifted the blame onto Vic. Maybe that's the story. Maybe that's what happened. I don't know. But if it is Monica, get out. Get out. Get out of this lawsuit. If that's what happened, if this is all because you're terrified of that thing, people will help you. Real people will help you. I will help you. Get out. No one deserves that. No one deserves to be abused and beaten by some little angry Napoleon complex pile of trash. Nobody deserves that. Kind of curious now what the real story is. Because I don't believe the story she told. Jimmy the Hand says, quote the Soye, don't hang up on me. Josh P says, greetings from St. Croix, Nick. Just got put on night shift now so I can finally listen live, and boy, is this a treat. You picked a good day. Picked a good day. Insert clever name here. Says she claimed she was a victim of a prior assault. What are the chances that the prior event was Ron? Yikes. I think that's low chances. Because she was talking about a long time before she met Ron. Blaine20 says, good thing it's Texas. I hear they have a he needed killing defense. Texan83 says, that is language I recognize very well. Language I remember from my childhood and my biological father, and the reason I have had zero contact with him in 28 years and never will. So glad I don't still live in Dallas. Listen, seriously, to all of you people who are supporting the victims, Occam's razor. Occam's razor. Vic's stories the stories about Vic, I should say, they don't add up. They don't add up because the way the defendants acted. Unless Ron is a monster, manipulated Monica, Marky's just stupid and went along to protect her friend, and Funimation has no idea because their investigation is garbage because their company is run like a 3-year-old bartering party. Okay? Ron Toye intimidating Monica to come out against Vic. Who else did he intimidate? He intimidated the twins? Twins never wanted to tell their story. Why didn't the twins want to tell their story? Did they know, they know about Ron? Why did it take him so long to tell that story? Did Ron force them to do that? Did Ron have control over the twins' job when they lived with them? What about Sarah? She's scared of Ron too? Perfectly reasonable for them to be terrified of this guy. Whose kids did he threaten? Whose pets did he threaten? Whose careers did he threaten? Clearly willing to destroy Vic's, right? And why? How embarrassing is it? How embarrassing would it be if Ron went to destroy Vic's career simply because Vic kissed Monica 7 years before Ron and Monica met? Who does that sound like? Well, that sounds like Maddox. That sounds like something Maddox would do. Go after someone's career over something years ago when they weren't involved anymore. Right? Ricky Intern Chan says, love that I can finally get to tune in. What a 30th birthday present this is. A treat. Thanks, Nick. Hey, Ricky, happy birthday. Hope to see you again sometime. Bryce Byerly says, I wish I could enjoy this revelation, but these are real women getting hurt. Yeah, I know. Like I said, I have so many jokes I want to tell, and I can't do it in good conscience. After this lawsuit goes down, we need to look hard at Ron's past. No, we need to look hard at Ron's past now. Everybody needs to look hard at Ron's past now. I don't mean go investigate him. I don't mean harass him. I don't mean any of that. Don't lie about what I'm saying. There are publicly available documents. They're going to get posted on Kiwi Farms, I'm guessing, in the next couple days, because I'm going to put them up on stream. We're going to go through them. I'm going to put them on stream. And I'm guessing other people are going to find them, and they're going to go back and pull this stuff. So it's coming out. There's no putting this genie back in the bottle, Ron, before you even think about it. Why does Lemoyne call them con sluts? Does Lemoyne and Wick Phillips like helping a woman abuser? Lemoyne complaining about me, joking and saying I want to see the liars ground into dust. He wants to see women ground into dust. Lemoyne, your client actually tries to grind women into dust, psychologically and physically. You're disgusting. I bet you knew about this too. Because I bet you did the research on your client, didn't you? I love it. I love how this always works out, right? This always works out. I don't know if you guys know this, but I don't talk about this much, but part of my practice, I hate family law. You know why I hate family law? Because I hate this stuff. I hate it. But when I do family law, when I do it, I'm getting women out of this situation. I'm getting children away from abusive dads. And I do it because I know the kid. I know the mom. I hate this stuff. I get accused of it on Twitter or whatever. I don't care. I let it roll off. It doesn't matter. They don't know me. They don't know anything about it. But I actually prevent this stuff. My job, I have saved women and children from abusive people. What have you fucking done other than tweet about it and lie about someone that you don't know? And support this sack of shit Ron Toye, who actually beats women. It's documented. It's in court. She had to get a protective order to get a divorce. She had to get a protective order to help get away from this scumbag. And guess what? Before anybody on the other side like say, well, it's one side of the story. No, they had a hearing. She was granted an ex parte temporary restraining order. 2 days later, they had a hearing and both she and Ron appeared at that hearing. Ron had a chance to say his piece. Ron had a chance to deny all of this, and the court found no, you're a scumbag. You've committed family violence, and you're likely to do it again if we don't get police to prevent you. If we don't get police to keep the women and children and dogs and judges in your life safe. We have to have law enforcement keep you from killing people, you sick little weirdo. That's what actually happened. That actually happened. It wasn't just an ex parte, one party affidavit. It's in the middle of a divorce. I've seen those cases too, okay? They had a hearing and the court said, this little munchkin is dangerous to the people in his life and has to be restrained from everything. And all the stuff she asked, she got it all. All of it. So have fun defending these liars over and over and over again. They have lied, 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 lied. You can see it for what? How many months are we at now? 7 months since January. They have lied again and again and again. And you people keep excusing it. Now, what are you going to do? Are you going to excuse this? Are you going to excuse that one of the defendants, the primary instigator of so much of this, the guy who texted Kamea Khan specifically? Monica didn't text Kamea Khan, at least I don't have the text from it. Maybe she did. I've heard Monica was on the phone with Kamea Khan at some point. Heard the same about Sabbath, by the way. But why would Sabbath support a wife beater? I don't know. Why would you, Sabbath? Maybe you're a scumbag too. That would be a shocking revelation if Chris Sabbath was also a scumbag piece of shit, wouldn't it? Anyway, the guy speaking on Monica's behalf, the white knight running out and tweeting 380 times. Is he a white knight? Is Ron the white knight? Or is Ron the possessive black knight? Is Ron trying to take command of the narrative because he wants to control us, or because he wants to control Monica? Think about it. You have supported liars. I'll forgive you. Some liars are good. You've supported liars after liar after liar after liar. But will you support someone with a documented history of abusing women, of threatening children, dogs, judges? Judges! This guy's so unhinged, he said he would kill a judge! Are you going to back that up? It's documented. I'm not making it up. It's documented. You just read it. And oh my God, am I going to try and get the transcripts from those hearings? You going to keep backing a woman beater? Maybe you should start supporting the women. I didn't know this until today. I learned this something at like 6 p.m. today. This has changed my entire perspective. It's changed my entire perspective. I thought Monica and Jamie were lying out of maliciousness. I think Monica's lying out of fear. I think Jamie's just stupid. And she's just going along and supporting her friend. But you know what? I'd forgive that too. I would forgive that in a heartbeat. if it came out that Ron was abusing and manipulating Monica into this. I'd even forgive Funimation. They were hoodwinked by this. I'm going to be real curious what all these people say tomorrow. Bartimaeus says, male feminists every... over obviously false allegations against a good man. Enough fucking said. The Big Fee says, damn, now I'm feeling bad for Monica. That nervous energy she had in her deposition, maybe it's because Ron was in the room judging and reacting to everything she said. Hope she's not actually a victim of physical abuse. Listen, Ron wore his little tight short t-shirt, show off the guns, show off the tats, show off how bad he is. Maybe he wasn't trying to intimidate Ty and Carrie. Maybe Ron was trying to keep his woman in line. Have you guys seen that? I've seen that. I've seen it more than I care to divulge. Sorry, I cut out. I killed the mic. I'm too worked up. What I was saying is, maybe Ron didn't wear his wife beater to the deposition of Monica to intimidate Ty and Carrie. Maybe Ron wore the wife beater to the deposition of Monica to intimidate Monica and to keep her in line. Keep that narrative on point. Have you guys ever seen that? You seen abuse? Seen real abuse. Seen lots of real abuse. Too much. Was a foster parent, been an attorney, defended women from scumbags like this. I've defended kids from scumbags like this. Blaine 20. Yep. Why were you divorced? I was an asshole. Understatement of the century. Yeah, he did say that, didn't he? Didn't he? He did state that in his deposition. I've forgotten about that entirely. Freighter J says, the crux of this is going to be how many of the Kick Vic allies change their stories. Now they see who they've been lying to defend. And how many new witnesses for Vic pop up as a result of these revelations. Listen. You people out there, you know Vic actually doesn't do this. You con runners, I've talked to you. You know Vic doesn't do this stuff. You can see it in 5 seconds. Anybody can see it. You turn on Vic's deposition and watch his initial demeanor. You turn on Ron's deposition and watch his. And one of them you go, oh my God, this guy is disgusting. And it ain't Vic. It's that little nasty weasel. You guys know Vic doesn't do this. You've all been hoodwinked and that's fine. It's convincing when a woman lucidly lies because she fears for her safety. I don't know if that's what Monica's doing. If Monica's backing up Ron and knows all of this, and she's not afraid for her safety, then she's terrible. But I'm not willing to put that judgment on her yet. Right now, I think Monica might be scared for her fucking life. And she should be. Bryce Byerly says, I guess Ty wasn't the target of intimidation when Ron showing up in the wife beater during Monica's depo. Yeah, yeah. I was singing the same thing, man. I was singing the same thing. Greg is doing damage control. Greg can't damage control his own fucking bankruptcy and his abandoned kid. Greg's a giant piece of shit. All right. DOG Beerus says Ron being evil does not explain Marky. No, it does. Marky, there's a direct message out there from Marky saying she rides with her friends to the end. Come hell or high water. She's ride or die, baby. Or whatever stupid butch language she's using. Marky's just a moron. Okay? If Monica is assuring her that it's all true because Monica is terrified of what Toye will do to her, then Marky's just a dumb victim. And dumb victims, we can mock them for being dumb, but they don't need to be part of a lawsuit. They don't need to be part of a lawsuit. If that's true, listen, Monica, Marky, Funimation, if you were hoodwinked by Toye, if Toye's got power over you, Monica, and if Funimation and Marky, if you guys are just too stupid or incompetent to figure out what was going on, you think people won't forgive you for that? Come out with it. Settle it out. Real easy to do. One affidavit. Boom. Ron Toye intimidated me. Ron Toye scared me. I feared for my life. Ron Toye has a history of violence on women. I knew about it because he's threatened and scared me. What was I supposed to do? Done. Done. Marky. My friend Monica Rial was threatened and intimidated. She told me that this was definitely true, but I just learned that Ron was the instigator. He was jealous of Vic kissing Monica years ago, and she changed her story out of fear. I went along with it because I was scared. For my friend. And I stick by my friends. Done. You're out. You're out of the lawsuit. No one cares. You don't have any money to take. You don't have anything you can do. Retracting the statements. Retracting the statements. That's all that really matters in this. Because if everybody was lied to by this little weasel, everybody can go back to normal. Everybody can go back and we can have what all of you pretend you wanted in the first place, right? Just a conversation about proper interaction between fans and VAs at cons. Great. We can all have that fucking conversation and everybody's lives can be a little bit more dull. SJWs can win this one, but a good man's name won't be entirely ruined. Funimation could hire him back. Monica can just say, you know what? It was actually a real abuser. And now we get to have a conversation about what real abuse looks like. All of that can happen. We can actually save people from the disgusting abuse of scumbags like Ron Toye, of Greg Doucette. We should get his divorce documents. I bet they're interesting. We can have all those conversations all day without ruining careers and detaching people from fans and detaching people from work. You guys win. You can have it. Let's stop the actual abusers from abusing actual women, okay? Let's do that. Let's focus on that first. Anyway, sorry. Ron being evil does not explain Marky Mars Girl. Mars Girl's dumb and stupid. Who cares? Han Leia, broke English teacher in Japan. Who cares? Sabbat, scumbag. Probably deserves to be on a cross. Schemmel, just an idiot. An idiot patsy for Sabbat who hates him. Hey, Schemmel, Sabbat hates you. So does everybody else. They just lie to your face. And you know it. And if you don't know it, I'm sorry you're hearing it from me. I don't hate you, buddy. I love Goku. He's hilarious. I'd still have a drink with you. You may hate me, and that's okay. I forgive you. I forgive you. Those people actually do hate you. Silly. The people who would probably be friends with you to the end, you actually push them away. The people who manipulate, talk bad about you, ruin your contracts. They keep you from going to certain cons. They do all this stuff. They try and gaslight you, try and inflame you. All of that. Those people you call friends, they're not your friends, buddy. But there's a lot of people out there who love your character and would love you. They really would. Vic included, I'm sure. You gave him the chance. I would. I'd have a drink with you today. I don't care. Funimation's just incompetent. They could be forgiven. Now, Funimation probably has to pay. It costs a lot of money, but they could pay really simply. Yeah, we'll hire you back. We were hoodwinked. Everybody was hoodwinked by this little coward. Everyone else who tried to destroy Vic, please don't use this to let Monica and everyone else off the hook. We got to see. Maybe they don't deserve to be off the hook, but maybe they do. Look, if someone's in fear for their life, they make actual irrational decisions. And they sound rational. They can sound lucid. They can be they can sound 100%. They can be the most convincing and competent liars when they're afraid for their lives and lives of their loved ones. Kilo Bravo 777 says, USS Rackets fires broadside cannons. Critical hit on the Spednot. Spednot taking on water fast. Away the fast action damage control Greg. Fenrir the Wolf says, damn, as much as we all hate Monica, him already physically, verbally abusing her is plausible AF. Hope that ain't the case. Me too. He's like that with women because he wouldn't so much as raise his voice to a man. Spineless little twerp. Fatal System Error says, I'm about 30 minutes behind. Here's for all the hard work you do. Rants are the best. All right. All right. Okay, I'm about done talking about this because if I keep talking about this, I'm going to keep getting mad and the stream will never end. But I don't want to talk all night about a disgusting, vile, petulant little abuser, manipulator. Oh, there are clues, by the way. He's talked about all of this in code before. His emojis. Well, when I feel my emotions taking over, then I resort to emojis to help remind myself where I am. Ron's had therapy on this, but I don't think he's actually recovered. When I say he's had therapy, I assume because his little emoji thing, talking about it being a coping mechanism, that's very specific language and very, very specific identity of a problem. I would guess Ron has had therapy over his abuse. I'm pretty sure he was actually ordered to it. So, why do you think he uses emojis? To cope with his fucking problems. I'm gonna eat some nerds now. I don't like eating on stream, but I need some nerds. Feed me, no, feed me. Tucker says, Greg's tweets are so soy-filled and pathetic, it's ridiculous. Hey, T. Greg. You next, bitch. You next. Figure you out real quick. Ricky Intern Chan says, for my birthday, I would like to fart into a CPAP machine, along with a side of butt puke for the taste. Get wrecked. Kilo Bravo 777. Sounds like a good Dallas Morning News article. Hey, Sharon. Hey, Sharon! Sharon Grigsby! Calling all bimbos, you dumb idiot! You fucking dumb idiot! You got hoodwinked by an abuser. You wrote an article in support of a fucking abuser. You dummy. You whitewashed this asshole's history of abusing women. You probably put Monica in more danger for your little filleting puff piece. You dummy. You disgusting dummy. You agendized pile of trash. You are garbage. Your reporting is garbage. You're a liar with an agenda. And you disgust me. You are the worst excuse for a journalist they could find. And they found you and put it down, hook, line, and sinker. You bit it because you're too stupid to do your own research, aren't you? You just took Lemoyne's little press release and you defended an abuser, you dumb bitch. You put other women in jeopardy, you dumb bitch. Oh my God. How stupid can you be? Protect women's, right? Right, Sharon Grigsby? You gonna change that article now, you liar? Every fucking time. Gonna write an article on this one, Sharon? Or are you just going to go like a good little dummy and go to the September 6th hearing and then take whatever press release Lemoyne gives you? Have fun. No one reads your fucking articles. All right. I said I gotta get off this. I gotta get off this. I'm gonna keep getting pissed off. I don't have enough pissed off in me for these people. Second. Here comes a Windows sound. Oh, it didn't. There it was. Sorry. Zach and Tawat, thank you. Kilo Bravo 777 says, should have left that hashtag #MeToo out of it also. Hey, Sharon, what about the women Ron beat and terrified and scared? What about them? Have you even considered that the women you wrote the article about are actually still at the hands of the abuser? And if you don't think that happens, if you don't think women are forced to shift the perspective away from their current abuser to some other person to take the eyes off the actual scumbag, then you're the dumbest, most naive journalist and you should turn it in. You should turn it in. Or talk to anybody who's worked with battered women ever and see if that doesn't happen literally constantly. I keep going back to these things, man. I'm addicted. Addicted to sugar. Well, let's see. I wonder if Dallas Morning News knows that they employed an investigative journalist who did so little investigation that she didn't turn up, that the subject of her article might be in a current relationship with a domestic abuser. I mean, she is in a current relationship with a domestic abuser. We're just not 100% sure that is current domestic abuse or not. I wonder if Dallas Morning News knows that. Journalism today, right? Hey, some rando dummy on YouTube can figure this out. You're a professional journalist, or at least you claim to be. You didn't even look, did you? Didn't even look. Oizopolis says, hey, Nick, keep up the great work with Vic. Could I request a plug of a Kickstarter by Andy Signor called Hugging the Cactus? Just like Vic, he was falsely accused, fought back and won. He wants to give others a voice. Thanks. I'm actually planning on having Andy on the show this week. We're just working out of time. We'll promote it heavily then. All right. We've got Karn says, it's freaking mind-blowing how in less than an hour, all my ire has been directed to Ron McCuckold. Hey, transcriber, get down. Ron Toye should eat a lead sandwich in Minecraft. Hey, yeah, Toye's transcriber, make sure you put some extra polish on this one. It'll be great when he raises this video in court. I'm seeing in chat. Shane's defending Ron's history of abuse. Marky's liking it. You know, it's fine. It's fine he was an abuser. I don't even know. Absolutely insane. I'll let everybody else do videos and compile all of those things. And I'm sure my colleagues will have a field day with the fact that these people are supporting a known abuser of women. Oh my God. Woo. I'm not gonna check Greg's Twitter. Nope, don't care. Don't care what he has to say. Because despite whatever Greg thinks, his Threadnought gets way less traffic. Way less traffic than this show will. And all the clips. And all the retweets talking about it. Hey, Greg. You're insignificant. Sorry. You aren't good at your fucking job. You aren't good at being a lawyer. And you're certainly not good at being a media hound. You're fucking embarrassing. And you're a piece of shit. Have fun. All right. Let's get back to this. Tucker says, for the record, a wife beater can be a cuck. Requires a special type of soy-filled cuck to beat a woman. A coward in every way. Every way. Okay. Let's go back to this. Don't leave. Don't leave. That's just like the PR side. This is just the public debate. Let's talk about the legal debate. Don't leave. This is important. We're getting right to the juicy part of this case. This case matters a ton. Matt Squared 2 says, hey, Nick, great job doing a little snooping. Got work tomorrow, so you and chat can have a great night. Hey, you too, buddy. Don't have an aneurysm, lol. Definitely going to have to rewatch the depositions. Cesario JPN says, and on that bombshell. All right, let's do it. Let's do it. In applying, it's holding that opinion. So we're right here. We're still talking about tortious interference with prospective business relations. We found out that the tortious interference with contracts, as you find in a lot of these appeals cases, it's defective pleadings and defective affidavits. You need lawyers with time. Hey, guess what Ty and his team have had? They've had time. They've had money. They've had the ability to research this stuff. They've had the ability to solidify their approach. They've had the opportunity that other lawyers don't have when doing these cases. There's a practical aspect of law that gets lost in all of the academic discussion by tuba-sounding Dumford, right? There's a practical application that gets just overlooked in all of this. It's time, it's money, it's bandwidth, it's expertise, it's all of those things. GoFundMe. Why do you think they hate it? Why do you think the lawyers on the other side hate the GoFundMe? Because it means that Vic's side is gonna get paid. Vic's side is going to get paid to do the work that their side can't afford to do. Let's talk about it. In applying its holding that opinions must be based on demonstrable facts and a reasoned basis, Supreme Court in Lipsky held that a statement in an affidavit that damages were in excess of $3 million did not meet the clear and specific prima facie proof standard stating. Range's vice president averred in general terms that Lipsky's statements caused Range to suffer direct pecuniary and economic losses and costs, lost profits, loss of its reputation, loss of goodwill in the communities in which it operates in excess of $3 million. The Court of Appeals concluded that the affidavit, by stating that Range had suffered direct economic losses and lost profits, was sufficient to raise rational inference that Range lost trade or other dealings as a result of statements made by Stephen Lipsky. Lipsky argues, however, that the affidavit is conclusory and therefore insufficient to satisfy the TCPA's requirement of clear and specific evidence, and we agree. Bare, baseless opinions do not create fact questions, and neither are they a sufficient substitute for the clear and specific evidence required to establish a prima facie case under the TCPA. Oh man, if only Vic had a way to prove the damages he would lose from each con. Man, if only Vic had a way. If only Vic had a history of going to all of these cons and could show at least an on average amount that he makes at each one and show the damages. God, that would be just so damn convenient, wouldn't it? Joel Navarro. Oh, wait, no. The Big Fee says, makes me wonder why Monica never set a wedding date. What if Monica's porcelain veneers are hiding the physical abuse Ron has dealt with his clenched fists? Can't believe that those are her actual teeth. Too much horse. Joel Navarro says, hey, Nick, there's a blog post called Attorney-Client Text Messages or Texting and Depositions Don't Mix. If I read it correctly, texts sent during depos are only privileged if they are sent during breaks. Maybe worth a look. All right. Here, as in Lipsky, there are no demonstrable facts or a reasoned basis for Kahn's opinion regarding damages because there's no evidence of any specific facts illustrating how these damages were calculated. Kahn has failed to provide clear and specific evidence of actual harm or damages sufficient to defeat Linden's challenge under the Chapter 27. Because Kahn failed to meet his burden of producing clear and specific evidence of a prima facie case for each essential element of the tortious interference with prospective business relations claim discussed above, the trial court erred by denying Vander Linden's Chapter 27 motion to dismiss as to this claim. Thus, we sustain this part of Vander Linden's second issue. Third issue, defamation/defamation per se. Pay attention, class. This is the one that really matters. This is the one that really matters. You want me to plug the GoFundMe? Greg is saying there's no case number. Oh, Greg, you sweet summer child. Thank you. Thank you for saying there's no case number. Where do you think I got the affidavit, you dumb fuck? You dumb bald idiot. You think I'm not going to show the rest of the case over the next couple days? Have you not learned yet how this works? I release something. You say something stupid, and then I go ahead and show that you are stupid. It's happened for 6 months, and your arrival didn't change that, you dummy. You only think it does because you're so busy with your mouth on your micro penis. That's it. That's it. You can, oh, there's no case number. Oh, but Greg, I've got the restraining order. I've got the divorce documents. I've got the divorce decree. I've got the petition. I've got all of it, you idiot. You think there's no restraining order? Guess what's coming out tomorrow, Greg? Guess what's happening tomorrow, idiot? Oh, you're so good at this, aren't you? You better tweet 95 more times tonight. That'll change everybody's opinion. And you better bury that tweet that says there's no case number because you're going to look really stupid when I put up the case number. Defamation/defamation per se. The elements of a defamation action include the publication of a false statement of fact to a third party that was defamatory concerning the plaintiff, with the requisite degree of fault and damages, citing Lipsky. To prove it, now pay attention. Again, this is what matters. This is what matters. To prove a defamation per se claim, Khan must prove the first three elements, but not the fourth element, as he would be entitled to recover general damages without proof of any specific loss. This is because, as defamation per se, the statements are so obviously harmful that damages, such as mental anguish and loss of reputation, are presumed. Khan alleges that falsely accusing someone of having admitted that he provided financial support to terrorists constitutes defamation per se. We agree. See Lipsky, stating that accusing someone of a crime of having a foul or loathsome disease or of engaging in serious sexual misconduct are examples of defamation per se. Therefore, to determine whether Khan's defamation action survived van der Linden's Chapter 27 motion to dismiss, we looked only for clear and specific evidence as to the first and third elements. So, they're defamatory as a matter of law. And the third element is with a requisite degree of fault. Now let's look at how they did that. Evidence of falsity. Pay attention. Pay attention. Van der Linden claims that Khan told her during a private discussion that he had given money to the Taliban. Khan denied that he told her that, swearing that, quote, "I have never given money to the Taliban, nor did I tell her that I have given money to the Taliban." In his affidavit, Khan also attempted to explain why van der Linden's claim should not be worthy of belief, urging that, quote, "it defies logic that he would make such a radical statement to a former colonel of the U.S. Air Force." The evidence Khan offered was clear and specific. Did you hear that, Law Twitter? Clear and specific evidence can literally fucking be just a denial of the truth of the assertion under oath. Did you hear that, you dumb piles of clingers on garbage? Did you hear it yet? You want to keep claiming that that's not how you show falsity at TCPA? Go ahead. It's right there in Tarrant County. You dumb pieces of shit. You dummies. How dare you be so stupid as to think that an affidavit under oath of a first party to an incident claiming that it didn't happen isn't evidence of falsity? What world do you live on where that's not true? The evidence Khan offered was clear and specific, that he had never given money to the Taliban, nor did he ever tell van der Linden that he had. And as van der Linden alleges that there were only two parties to this oral communication, Khan could hardly offer more to refute her claim. Thus, so not only does Vic say that the Monica thing never happened, only two parties. The only other party that may have any knowledge of it is Stan Dolan, that Monica raised, and then Stan provides an affidavit to Vic saying, "I don't remember any of that." Oh, fuck me. You're done. You're done. And wait for the next part. Wait for the next part. The evidence Khan offered was clear and specific. That he never given money to the Taliban, nor did he ever tell van der Linden that he had. And as van der Linden alleges, there were only two parties to this oral communication. Khan could hardly offer more to refute her claim. Thus, as to the first element, whether the message that Khan had personally told her that he had given money to the Taliban was false, Khan met his burden under Chapter 27 to establish by clear and specific evidence a prima facie case for the essential element of falsity. Hey, Billy, you motherfucker, how do you think you prove falsity? You just have to assert it at TCPA when there's only two parties. I told you that, and you didn't believe me. The dissent argues that if Khan's statement that he did not tell van der Linden that he gave money to the Taliban can suffice as clear and specific evidence to defeat van der Linden's motion to dismiss, then van der Linden's statement that Khan did tell her that he gave money to the Taliban would suffice to meet van der Linden's burden to prove the affirmative defense of truth. Either way, the dissent argues the trial court was required to dismiss Khan's claim. Uh-oh, what's this about that affirmative defense of truth? Oh, shit, I think you might have a problem, don't you? Here it comes. Here it comes. The logic of this argument is appealing, but we must also consider history and precedent. Oh, mustn't we? At common law, the falsity of a defamatory statement was presumed, and truth was an affirmative defense. Hurlbut versus Gulf Atlantic Life Insurance. Regarding falsity, the common law presumed the defamatory statement to be false, and truth was a defensive matter. But in 1964, the Supreme Court shifted the burden of proof for cases that implicate First Amendment rights. New York Times versus Sullivan. Now, when a case implicates constitutional issues, i.e., when a case involves a public official, a media defendant, or a matter of public concern, or any combination thereof, the burden is upon the plaintiff to prove falsity, not upon the defendant to prove truth. This is important. Stick with me. This is important. Philadelphia Newspapers, Inc. versus Heppes, placing burden of proving falsity on plaintiff in case involving private individual and media defendant on a matter of public concern. Huckabee versus Time Warner Entertainment Company, placing burden of proving falsity on plaintiff in case involving public individual and media defendant on a matter of public concern. Casso versus Brand, placing burden of proving falsity on public official plaintiff in a case involving private non-media defendant on a matter of public concern. Okay, if it implicates the First Amendment, burden of falsity is on plaintiff. Yes. How do they make a prima facie case that it's false? In some sets of facts, especially when there are only two parties to an action, all you have to do is allege that it's false. And it's in the document because there's no other way. It doesn't make logical sense to treat it any other way. So when you say there are two parties to an act, and one of them is the plaintiff, by merely asserting the falsity in a specific and clear way, has met his prima facie burden of showing falsity for the purpose of the TCPA. Do you hear me, you idiots? Do you hear me? I hope you hear me now. Now, again, stick with me. It gets worse for them. In 1985, however, the Supreme Court breathed life back into the affirmative defense of truth when it held that states, like Texas, could apply the common law to defamation actions that did not implicate the First Amendment, i.e., actions between private individuals and non-media defendants involving private issues. Although the message here was part of a private dispute between a private individual and a non-media defendant, we have also held that the message was not a private issue, but a matter of public concern. Now, what has the defense in this case argued over and over? This is a matter of public concern, and it implicates the TCPA because it's a matter of public concern, right? Here we go. Therefore, even considering the holding in Dun and Bradstreet, the common law affirmative defense of truth still does not apply. Thus, common law principles do not apply, and van der Linden bears no burden to prove truth. What does that mean? Because that sounds good for the defendants in this case, but it's not. There's no burden to prove truth because the burden is on the plaintiff by clear and specific evidence to make a prima facie showing of falsity, which they can do by merely alleging clearly and specifically that the event between two private individuals did not occur. That's it. They've met their burden. Now, the affirmative defense of truth does not apply. They don't get to raise an affirmative defense. So upon making a prima facie showing of falsity, no affirmative defense. You don't get it. And they're going to hammer that home in just a second. Practically speaking, if the law were otherwise, it is difficult to envision how the jury would be charged. Remember, Ty and I talked about this. How could you prove something is false only to have someone else come in and prove it's true? That doesn't make sense. Why doesn't it make sense? Because it's not how it works. And then, on one hand, the jury would be asked to decide if the statement was false. And then on the other hand, the jury would be asked to decide if the statement was true. Instead, pattern jury charge 110.4 instructs trial courts to place the burden of proving falsity on the plaintiff by asking, was the statement, insert matter alleged to be defamatory, false at the time it was made as it related to Paul Payne? Commission on Pattern Jury Charges, State Bar of Texas, Texas Pattern Jury Charges Business, PJC 110.4, 2014. Then it further instructs that the affirmative defense of truth question, PJC 110.8, which asks, was the statement substantially true at the time it was made as it related to Paul Payne, should be submitted only in cases involving a private party plaintiff regarding a matter of exclusively private concern. No jury instruction for an affirmative defense of truth. It's gone. It's out the window. You don't even get it. You don't even get it. If there were any remaining doubt on this point, are you listening out there, Law Twitter? Are you listening? Because it's funny. You said I was wrong on this issue, but the entire time you've been incorrectly stating the law. Big fucking shock. Big shock. You got stuck in your little academic circle jerk, and everybody was busy wiping the semen of the next person on them, saying, oh, you're so right. You're so right that you failed to actually address what the law is. And you thought you were doing a drive-by. You thought you were doing dunks. And as people pay less and less attention to you, we'll all laugh as your invalid opinions are left in the fucking dust. How embarrassing for you. How embarrassing for you. If there were any remaining doubt on this point, the Supreme Court has recently addressed this identical argument. In D Magazine, the court held that on matters of public concern, plaintiff bears the burden to prove falsity and the affirmative defense of truth does not come into play. Does not come into play. D Magazine argues that even if we conclude that Rosenthal established a prima facie case of defamation, it is still entitled to dismissal under the TCPA because it has established the affirmative defense of truth by a preponderance of the evidence. We disagree. Although truth is generally a defense to defamation, the burden shifts to the plaintiff to prove falsity in cases involving matters of public concern. Falsity is thus an element of Rosenthal's defamation claim. By contrast, an affirmative defense, such as the statute of limitations, is based on a different set of facts from those establishing the cause of action and defeats the plaintiff's claim without regard to the truth of the plaintiff's assertions. Zarilla versus APCO construction. Because falsity is an element of Rosenthal's claim. At this stage of the proceedings, she was required to make a prima facie case by clear and specific evidence that the gist of the article was not substantially true. As discussed, Rosenthal has met this burden. You don't get out of it. You don't get to continue the TCPA with your affirmative defense of truth. Your ship is sunk. It's sunk. Thus, the Supreme Court has rejected the argument that in a case involving a matter of public concern, once a plaintiff has met his burden to establish by clear and specific evidence a prima facie case for falsity, the motion to dismiss can be defeated by providing evidence to the contrary. The Supreme Court has rejected the argument that a prima facie case for falsity can be defeated by providing evidence to the contrary. You're done, you idiots. You have two options. Either this is a matter of public concern and TCPA applies, your affirmative defense of truth does not apply. Or it's not a matter of public concern in which the TCPA does not apply unless Vic is a general purpose public figure and you know you're losing that. And then if the TCPA doesn't apply, it's frivolous and you're fucked on fees, and I'm going to laugh in your face if that's what you have to do. But we're not done, are we? Because if we were done, this case would almost be just devastating. It would only be devastating if we were done. But this case is Hiroshima to these people. Let's move on, shall we? Evidence of degree of fault, negligence. As to the third element, whether the publication was made with the requisite degree of fault, con status determines the degree of fault to be applied in the case. See Lipsky. Because Khan was a private individual rather than a public figure or official, Khan need only prove that van der Linden acted with negligence. Stick with me. I'm not even going to argue that Vic is a not public figure because it doesn't even matter. Let's read on, shall we? CWFAA-TV Inc. versus Macklemore, explaining that a private plaintiff must prove only that the defendant was at least negligent, whereas a public official or public figure must establish actual malice, which is a higher degree of fault than negligence. Van der Linden argues that Khan failed to prove negligence because he failed to offer any proof that she knew or should have known that the statement in question was false. The dissent voices a similar concern that Khan failed to produce clear and specific evidence that van der Linden failed to investigate the truth or falsity of her statements before publication. These both reflect correct statements of the law, but here, this case's specific facts drive the analysis, and they always do. And this is going to be Lemoyne's job, to try and show how this is different. But it's not on everything different. On a lot of things, it's specifically not different. Here we go. Had the message stated that Khan has given money to the Taliban, we might debate whether there is any evidence in this record that van der Linden knew or should have known that the statement was false, or whether she had a duty to investigate prior to sending the message. But van der Linden did not say that. She said Khan had told her personally, not via hearsay, that he has given money to the Taliban. It happened to me! It happened to me! Right? Right? It happened to me! So, with regard to the truth or falsity, the question is not whether Khan gave money to the Taliban. The question is whether Khan told van der Linden that he gave money to the Taliban. This fact narrows our analysis considerably. According to van der Linden, she and Khan engaged in a private conversation. During that conversation, either Khan said that he gave money to the Taliban, or Khan did not say that he gave money to the Taliban. Only the two parties to the conversation, van der Linden and Khan, know which proposition is true. Because van der Linden knows the truth, whatever it may be, if Khan did not say that he gave money to the Taliban, then van der Linden's assertion to the contrary was not only false, but was also made with knowledge that the assertion was false. So even though he's held to a mere negligence standard, they went all the way to knowledge of the falsity, which is the actual malice standard. Monica knows whether or not Vic forced himself upon her in that room. She knows it. There's only two people in this world who know that Vic forced himself upon Monica in that hotel room, and it's Vic and Monica. No other person. And they even said, well, Stan Dolan's affidavit doesn't matter because only Monica and Vic know the truth, right? Only those two. Well, great. You just made actual malice. Hey, Billy fucking Haywood, are you paying attention yet? Are you paying attention? I told you this is how it worked. You said I was a bad attorney for it, and I'm fucking right, and you're wrong. You dumbass. Of course it works this way. There's no other way it could possibly work. Either Vic assaulted Monica in that room, or Vic didn't assault Monica in that room. There's only two people who know. And Monica's one of them. So if Vic says he didn't, he has met his prima facie burden. Fuck you. Eat shit. I'm so tired of these people. I am so tired of these people. Oh, baby. Oh, baby. All right. And yes, that goes all the way up to actual malice because of course she knows she's lying. Because van der Linden knows the truth, whatever it may be, if Khan did not say that he gave the money to the Taliban, then van der Linden's assertion to the contrary was not only false, but was made with knowledge that the assertion was false. In other words, if it was false, then van der Linden knew it was false. If it was true, then van der Linden knew it was true. Either way, van der Linden knows the truth, as does Khan. And under these narrow facts, any evidence that proved that van der Linden's assertion was false would also logically and necessarily prove that van der Linden knew that her assertion was false. Monica is toast on TCPA. She's done. Van der Linden argues that allowing the same evidence to prove falsity to also prove the requisite degree of fault would, quote, return us to the strict liability theory in United States Supreme Court found to be inconsistent with First Amendment protections in Gertz versus Robert Welch. Hey, Parker, I've seen you throw that out. Guess what they're about to do to that? This argument, while facially attractive, unlike you, dummy, misses the point of Gertz. While the Supreme Court in Gertz did reject the notion of strict liability in defamation actions, it explained its holding to mean that states are not free to impose defamation liability without applying some standard of care to the conduct, stating, "We hold that so long as they do not impose liability without fault, the states may define for themselves the appropriate standard of liability for a publisher or broadcaster of defamatory falsehood injurious to a private individual." By holding that under these circumstances unique to this case, the same evidence that proves falsity also proves the requisite standard of liability, we do not dispense with the element of fault. We merely acknowledge the inescapable, logical conclusion that if the facts conclusively prove that the publisher of the defamatory statement had personal knowledge of whether the statement was true or false, like grabbing and tugging the hair versus just maybe bouncing it or touching it, whispering something sexual into her ear versus not whispering something sexual into her ear. That little detail, Marky, that detail probably sunk your case. Because if it's a whisper, guess what? Only you and Vic know what was said. And Vic said he didn't say anything sexual. And you said that he did. Uh-oh. Uh-oh. You done fucked up. Let's see. Had personal knowledge of whether the statement was true or false. Proving the statement false also suffices to prove that the defamatory publisher acted with knowledge of the statement's falsity when she published it. Van der Linden need not conduct an investigation to determine whether the content of the message was true or false, because under these limited facts, at the time she sent it, she already knew the answer. Thus, for the same reasons that Khan met his burden under Chapter 27 to provide by clear and specific evidence a prima facie case for falsity, Khan has also satisfied his burden of providing clear and specific evidence of a prima facie case that Van der Linden knew that the statement in question was false. Khan offered clear and specific evidence that he did not tell Van der Linden that he had given money to the Taliban. Van der Linden admits that she and Khan were the only two parties to the conversation. Under these unique facts, if at trial Khan proves that the assertion was false, he will have provided proof that Van der Linden knew that it was false when she published it. Just because under these facts, the same evidence that proves falsity would also prove knowledge of falsity does not mean that Van der Linden would not be held to the knew or should have known standard of care. The dissent argues that because Khan sought exemplary damages over and above his general damages, he must prove a higher standard than mere negligence. First, neither in her motion to dismiss nor in the hearing thereon did Van der Linden challenge Khan's entitlement to pursue exemplary damages in connection with his defamation/defamation per se claim. By the way, exemplary damages and defamation per se, guess what the standard is? Actual malice, the same standard for public figures. Why do you think the court's talking about it? Nor did Van der Linden argue or brief this contention on appeal. But even if this issue were fairly before this court for determination, this contention would fail. While we agree that to recover exemplary damages, Khan's proof must ultimately meet a higher threshold, a higher degree of fault, proof of malice or gross negligence, a more stringent burden of proof, clear and convincing evidence, and the vote of a unanimous jury, these heightened standards do not alter the elements of Khan's underlying claim for defamation per se. These additional burdens act only as a potential barrier to the damages Khan might recover should Khan prevail in his legal action for defamation per se at trial. As will be discussed below, the TCPA applies to dismissal of cause of action, not remedies, and while obtaining an award of exemplary damages might require further proof at trial, the elements Khan must prove to recover general damages under his legal action for defamation per se remain unchanged. Because we hold that Khan met his burden of producing clear and specific evidence of a prima facie case for each essential element of his defamation per se claim, we overrule the remainder of Van der Linden's second issue, challenging this claim, and affirm the trial court's denial of Van der Linden's Chapter 27 motion to dismiss Khan's defamation per se claim. I don't know if we should finish this case. It doesn't really matter. Here's the dissent. Who cares about the dissent? Here's the last bit of it. Request for injunctive relief. Let's see. Yeah. They're not going to even deal with this, I don't believe. Without reaching Vanderlinden's argument regarding constitutionality, we overrule her third issue. They didn't grant injunctive relief. Request for attorney's fees. Blah, blah. Yeah. So she got attorney's fees on the 2 causes of action that were dismissed, and the other action was allowed to go on. There you go, guys. That's it. This has been a bad day, I think, for the defendants. This has been a bad day for the defendants. Of course. Of course. We will find out what happens. We will find out what happens after the TCPA hearing and a ruling comes down. But the lawyers giving this a 100% chance of success? Sure. Sure, pumpkin. Go back to your pro se defense of drug dealers, you disability-addled idiot. We'll see. I'm gonna bet this case plays heavily. This Fort Worth Court of Appeals case plays pretty heavily into Ty Beard's defense against the TCPA motion. I'm gonna wager just a little bit that maybe this case will come into play. Maybe. I don't care what Shane's saying. Shane's the dumbest person on the planet. And it does no harm to the case or anything at all. Sure. Oh, you know what? You know what else is probably going to play during the closing argument at the motion hearing? I'm betting there's going to be a video of Monica getting spanked in public. I'm betting there's going to be some video clips of panty, stocking, and garter played in that courtroom. I'm going to guess that's on the menu. And they're going to talk about, hey, Funimation, this one's for you, buddy. I'm betting they're going to talk about the lunacy. Because remember, Funimation has not testified as to what they investigated specifically. So the only things we know they investigated are whatever Vic says, because that's what they called him about, right? Jelly bean, consensual kiss, advancement upon 2 adult women off company property at a convention. That's it. So I wonder if it's going to be persuasive to go ahead and show the highly sexualized nature of Funimation as a workplace, in contrast to allegations that he was fired over an investigation that consisted of eating a jelly bean and telling a dad joke, a consensual kiss in an office, and then asking for consent from 2 con sluts. I wonder if that's going to be persuasive and maybe have an impact on Funimation's TCPA. How does this work? How does this play out in a motion hearing? Here's the trick of a motion hearing. It's keeping the judge focused on what the law is. It's keeping the judge focused on what prima facie means, on what clear and specific means, and on what this case and any other persuasive cases say. It's a matter of keeping the judge, because judges have to listen to these long arguments. They have to hear all this stuff. They have to absorb all this information. It's about focusing the conversation on exactly what the standard is. And that's prima facie evidence, or prima facie case, by clear and specific evidence, which can be an affidavit merely alleging the falsity, so long as that allegation is clear and specific and there's no other potential source for the falsity of the statement. Now that's going to apply to Monica's interaction. That's going to apply to Marky's interaction. Toye's interactions are going to be different. He's a third-hand cuck. He's going to be talking about this. Although there's other problems with that. Marky and Toye have submitted a joint petition for their TCPA, which might mean that if either of them go through, then both of them go through, since it's impossible for the court to delineate which claims and defenses apply to which one. If they're trying to act as a singular unit, maybe the judge will just go ahead and treat them as a singular unit, which means that Ron will be imputed with the knowledge that Monica had about that night. And if that's the case, Ron's toast. But Ron's already toast. Ron has shown over and over and over again that there is circumstantial evidence of malice. He has stated that he flat out did not read anything except for Pretty Ugly Little Liars. And what he read on Pretty Ugly Little Liars, he accepted without question. You think that's not a prima facie case of reckless disregard for the truth? Good luck. Good luck. Either way, it doesn't matter. Marky and Rial, their specific statements involve only two people each who would know the outcome. They're done. As long as a judge applies the law properly, they're done on TCPA. Funimation, they know the truth of the investigation. They know what's in there. Also, if there's any contact with the of an agency relationship, and all they have to do is provide clear and specific allegations of an agency or employment relationship, and they've got all sorts of it. They've got Scott Barretto acknowledging that he reads all social media and articles. It's his job to know what's going on social media regarding Funimation, and they did nothing to correct what was said about Vic. Not a single thing. All it would take is one tweet. These voice actors are independent contractors and do not speak for Funimation. They didn't do it. Why didn't they do it? Because they needed that narrative. They benefited from that narrative in their own minds, and that's what they wanted to convey, that Vic was fired for the investigation. They're going to go in there and argue that that's not true based on Scott Barretto's statements. They're going to try and argue that, and they're going to get absolutely bored out. Absolutely bored out by an argument to the contrary. Good luck, Funimation. Your TCPA's toast too. Now again, a judge can always disagree. Judges are people. If they disagree, there's an appeal. And there's going to probably be several appeal points if they do disagree. However, this case, applied to many of these facts, show that Fort Worth ain't having it. Fort Worth ain't having it. And by the way, I've heard that Fort Worth specifically doesn't like TCPAs. I'm not the only one who's heard that. Why do you think this Court of Appeals ruled in this way? They don't like TCPAs. But we'll see. I would never put 100% odds on passing a motion, on winning anything in court. Never have, never will. But I believe that Vic's case is about as strong as it could be. Those depositions were the stupidest things the defendants could have done because they afforded time and they afforded a bunch of evidence that didn't exist. And the only person who needs to show evidence in this is Vic. Vic's the only person who needs to show evidence. That's it. Their ability to controvert evidence is going to be crippled. They don't get an affirmative defense of truth. Good luck. Certainly not going to win on an affirmative defense of hyperbole because you flat out said, no, I mean it. He's a sexual assaulter. All right. I think I'm done ranting for tonight. This has been a lit up episode. A lit up episode. Whew. Let's do chats. Let's do chats. Oh, here we go. There's some sorry, there's some 20s that I missed. I got to get back to the spot. Cloudfire 181 says, holy hell, Nick, WTF did I just walk into? Regardless, if Monica is being threatened and beaten by this POS, she needs to get on her hands and knees, ask for Vic's forgiveness for what happened. Ron needs the old Yeller treatment in Minecraft. Intimidator 0108 says, Ty Beard is leagues of more of a real lawyer than your sorry butt will ever hope to come close to being, Greg. Maybe you and Shane Holmberg can help each other get each other's heads out of your butts. Joseph TX says, I am Joseph Guillaume of Harris County, Texas. I invite Ron Toye to sue and or depose me for providing these documents to Nick Rekieta. P.S. Who's making fun of domestic violence charges now? Greg, you bald prick. Peachfish says, take my super berry cherry lawbringer. Can't wait to catch up on all this later. Ron Soye can go die in a fire in Minecraft. Kilo Bravo says, yo, John Kelly, you need to cover this on your channel. Sprite Cola says, can we have a quick TLDR? Ron the real offender and truth debunks Monica's case either way. Ron has a history of domestic violence. You'll have to go back and watch it. Starts exactly an hour and 1 minute in to the show. I can't recap it all. Just know that he's toast. I think I missed this one from Joseph TX earlier. Says, don't underestimate a Texan. Glad my little walk through Fort Worth bared such fruit today. To Ron, I'm not scared of you. Please make good on whatever little threats your little mind can make up towards me. I'm waiting. So there we go. Oh my goodness. Let's see. We got Justice Chats here. We've got Mercenary X says, wait, Nick is early. What is this heresy? I call for an exterminatus unless one of Nick's kids try being as sneaky as an Eldar or they bring back that mini Wah. In all seriousness, let's see what SJW brains you can make explode. TLJ Screwjob says, any chance of getting pro Jared on the stream? I can reach out to him. Not now, since he's still going through his divorce and he and his lawyer don't want to give his ex any ammo, but maybe after it. I'll reach out. I don't know. Ken Wolf, thanks for the donations. Mercenary X says, I wish I could have met Weird Al. Mind you, my mom and sister knew his parents, and I met them a few times before they died since we lived in the same area. My sister got to meet Weird Al, but I didn't get to, and I'm the Weird Al fan. I wish I was kidding. Sorry, buddy. Unknown Watcher says, holy, when he showed up to court with the wife beater shirt on, remember? I do. Kay said, when he showed up in that wife beater for Monica's deposition, we thought he was trying to intimidate Ty. What if he was trying to intimidate Monica? You guys were all firing on the same wavelength I was. Mercenary X says, God help Ron because this SOB won't get any from me. Anyone who harms animals just one step away from going after humans. Common if Ron ever said that to me, God help him because I would take every word he said as if he wanted to kill me. Self-defense. God, I just realized the comment I said about having a horrible bad feeling off Ron was right when you did the deposition video. For the love of all that is holy, I knew he was guilty of something. This guy is just short of committing murder. I knew it. Gay and Still at Large says, Nick, I don't have much to give tonight. Oh, no worries, buddy. But I wanted to show a bit of support for standing against this cunt. He beat his wife in front of his son. As someone who grew up with a violent father, I can't articulate how much I hate this animal. Books, games, pottery says, God, this makes me so sad. I hope Monica's not being abused. Me too, legitimately. But it would be a miracle if she's not. And to be honest, his emotional abuse could have her so twisted around that she actually has rewritten her history with Vic in her mind. Not unusual. Not at all. Mercenary X says, I said he was guilty of something like he was guilty of what he accused Vic. God have mercy and help us all. What if Ron has total control over everything and everyone at Funimation? I wouldn't go that far. I think Funimation's just incompetent. At this point, I won't be surprised if he wants to kill judges or something. Citizen of Yarnum says, holy shit, Nick just made me feel bad for Monica. Did I wake up in a goddamn parallel dimension? Quickly, how do you spell Berenstein? Not like that. Nick, if this is true that Monica gets beat by Ron, then yes, we need to help her. But I don't know for sure that she's 100% innocent. Me either. Me either. I'm just telling her if she is, get out. Why would her, Dominique Sky, and Jamie make a video giggling and saying conspiracy at the same time just saying, only matters what Monica has told those two. And if Monica's an actress, she's scared and she's convincing, could be a lot of stuff. Baron von Stargart says, Sheepdog put his Twitter in protected mode. Commence exterminatus on this cowardly mother effer. Seems pointless now, but I would really like the chance to forgive Monica. Jay said, I left an extremely abusive relationship with a female. The language in the document is still left in voicemail messages for me every so often. 83 so far this year. If it's happening to Monica, get out while you can before you end up in a hospital like me. Not Nice says, don't forget Jamie is living with someone in the Tuttle group. Likely friend to Ron Toye. Jamie potentially another scared victim or just stupid. Facetious Sage says, even if they were hoodwinked by Ron's manipulation. Oh, hey, I should put my stupid face bigger. Even if they were hoodwinked by Ron's manipulation, I can't forgive Funimation because they still had a duty to properly investigate the allegations. They didn't even bother trying. Ron Toye is trending on Twitter. That's too bad for him, isn't it? I wonder if the Tuttle group knows what he's done. Let's see. We've got... Kay says, I wonder if there are any tweets from Ron where he replies to people saying something along the lines of not as bad as Vic or an abuser like Vic. That would directly contradict what he said, and his lawyer verified every single one. Effing whoops. Revelation says, the leftover of GoFundMe goes to Salvation Army, Dallas Domestic Violence and Abuse Shelters in Dallas County, Texas. How poetic. Could some of this actually end up with Ron's victimized ex? I don't know. TLJ Screwjob says, to quote Han Leia, hey, Tuttle Group, why do you employ a known domestic abuser? Can we spam the Tuttle Group with this on Twitter? I don't ever recommend doing that. You guys do what you choose to do. Anon says, slightly on topic, if you know someone that has been abused, most hospitals, police stations, and fire departments have a victim advocate. Make a call. I beat Tal like Ron beats women, says, I wish I could afford to give more. You, sir, are the culture war's greatest warrior. Keep up the fire. Pro Hero All Might says, every time you say Vanderlinden, I have the sudden urge to book a flight to Tahiti. Okay. All right. Now on to Super Chats. NGE Fan 76 says, damn it, Nick, I got to get up at 4. Guess I'll find out what this is in the morning. Oh, good luck. Blink Your Eyes 1400 says, would this ever work as a proposal in the Moini voice? Will you be my con slut? Maybe. Prof West says, 12-hour day today, probably 12-hour day tomorrow, but you said this was a stream to watch, so here I am. May the sheepdog watch over me at work tomorrow. Itchicinco says, here's $2 for being 2 minutes early, boomer. Oh, tomorrow I'm going to be 3 hours early. Gareth Bryant says, is it midnight yet? No, you had 57 minutes to go. Palix Tobin says, Santa, what would you like for Christmas, little boy? Lamar, have you ever heard of a con slut? Bird Stork says, hey, Nick, Bird and Riley listening, excited for tonight's stream. Hey, Bird, how are you guys doing? Kalinka Pavlova says, you won't read this for ages, but did someone settle? Oh, no. No, but they might want to consider it. The affiliate says, will Ty be on after the 8th to explain why Vic lost his case? Kidding. Ninja Work 111 says, my normie friend is concerned things aren't going well for Vic. Could you bring her fears to rest? Base lawyer man? No. I can't. I can't do that. I will think that things are going just fine for Vic. I think things go poorly for the defendants on a regular basis, and today is no exception. So they just have to watch. Mike Lombardo says, hit that like button. TLJ Screwjob says, she makes me regret being in Air Force ROTC. Blaine 20 says, Oilgate. Jay Prez says, I warned you to toss that vile substance. Oh, it's so gross. Goofus Maximus says, enjoy your West Nile lawyer juice. No. Kyle Fairchild says, love you, Rekieta. Hey, back at you, buddy. Barb Rogers says, beware of false flaggers. That bish Zoe Quinn just got the quartering live stream taken down now. Reborn exists. Oh, I read that one. Anthony Pacheco says, more like gamma weasels, trademark. Ninja Work 111 says, speculate why male femmes do this crap. What's the pattern? I don't know. I think they're just trying to deflect attention from their own actions. It's not why they do this. They do this and become male feminists to deflect. That's how that's the chicken and the egg outcome there. Baal of Babylon says, this thing is so cult-esque with Toya and Sabbath being the leaders. Vic is the type every cult has to destroy. If this is the case, it is likely Monica and co are stuck / need help out. Hashtag save Monica that, or Monica is part of it. Blink Your Eyes 1400 says, wait, the soy-filled bag had a kid, press F for kid. Addie M says, this isn't even a fatality, it's a brutality. Boxlord Hunter says, I can't wait for Mr. Toye, did you beat your wife? I do not recall. Reset the clock, 0 days since male feminist outed as an abuser and or sex pest. Matthew Neidig says, a feminist ally turns out to be calling the kettle black, projecting onto others the bad behavior they themselves are guilty of. What a shock. What a shock indeed. Gamer Hands Jr. says, Mr. Rekieta is going beastly mode. Kalinka Pavlova says, so Ron's an actual wife beater. I almost can't believe it because he looks so effing pathetic physically. Hope the transcriber is getting this. Ninja Work 111 says, kicking Ron's head off in Minecraft be illegal? Yep, still illegal. Shining Nebula says, wow, if Ron's actually abusing Monica, then I feel a little bad for her. No idea if he is or not. Nobody deserves that treatment. As for Ron, finish him, Nick. Kalinka Pavlova says, he got their son to hurt his own mother. Sickening. Blink Your Eyes 1400 says, is this going to look bad in the eyes of Ron's employers? I don't know. Kalinka, that's actually, that was his stepmother. I believe that son is from his first marriage. First marriage, not his second marriage. Kalinka Pavlova says, this I believe. Why? Because it mirrors my own experience. I am so sorry to hear that. Nichols in Minecraft says, press S to spit on Ron woman beater Toye. Official Rogue Ent says, you're a stand-up guy. Love your streams. Ron Cucklord. Hey, thanks, buddy. E says, well, Psycho Ron just lost their case. Rip kick Vic. Emmett says, he seemed like a spineless coward during his deposition. In Vic's case, a true wolf in sheep's clothing. Christopher Wall says, I wonder if Ron's transcriber also has to look at all the chats. Well, either way, he now gets to see who his employer is. Unhinged Crank says, Nick, will the judge allow this to be entered, or will it be deemed prejudicial? We'll have to see. We'll have to see, won't we? Daddy LP says, I don't know who is worse, Ron or all the thread nuggets who are sure to be defending him first thing tomorrow morning. Despicable. They didn't even wait till tomorrow morning. Didn't even wait. Courtney Leas says, Doucette today compared Vic to Harvey Weinstein. Did you see that conversation? I don't read what Doucette has to say. If people send me stuff, I'll occasionally see it, but otherwise I completely ignore him. He's irrelevant. He's irrelevant to the case. He's irrelevant to me. Alex Theroux says, where was this at deposition? Didn't know about it at deposition. Nobody knew about this until today. Unfortunately, wouldn't that have been great? Bob Jones says, Nick just watched Pro Jared's apology. Sounds a bit like libel. Love to hear your take. I'll have to look at it. Matthew Neidig says, during Depo, Ty used the words, when did you stop beating your wife? Question as an example of an unfair ask. Ironic how close to home he actually was. Alex Bridden says, Nick, remember that MMA fight that you joked about a while back? I want to see that even more now. I knew that Ron Soye was a slimeball, but holy shit. Kalinka Pavlova says, Monica, if Ron hasn't hit you yet, he will. Abusers are slow to learn. My ex is on his third baby mama after me, And number 2 got protection orders against him for domestic violence. Get out of there. Jonas Traber says the twins worked with Ron and lived with him. Could he have coerced them into making up the forced kissing story? Maybe. Maybe. Joel Navarro says, hashtag ruin Ron. Blue Satoshi says, Soye had depot prep. Rial didn't. Kind of puts things in a new light, besides their money running thin. Brett Wyatt says, for the first time in this case, a real victim steps forward. Nathan Kish says, I came in late into the middle of all this stuff about Ron. I'm shocked, genuinely shocked that Ron Soyboy is actually dangerous. E says, or they're just as nasty as him, a perfect match. JJ Death says, so Maddox and Ron must be the same person. Blink Your Eyes 1400 says, will this revelation affect the case? I don't know. I don't know if it'll affect the case, but I think it might already be having an impact on the public perception of one of the defendants. Nathan Pudrier says, just joined the stream. Quick rundown of what I missed. Dequarius Walker says, whoa, Nick, why Ron gotta be a Black Knight? A good point. Sorry. Green Knight, we'll say. Grunu says, let's see who walks away from this a registered sex offender. Ronald Joseph Toye III, hashtag Vic kicks back. Xvarna says, Ron's transcribers having fun about now? Thank God we can rely on abusive cucks like Toye to keep us safe from Vic hugs. Way the hell to go, sheepdog. 99 Iron Duke. Says, eating jelly beans is evil, but hitting women and threatening to chop up poor dogs is perfectly okay. Tom Tell says, would love to hear Drexel's opinion over this Soye stuff. Bet he goes wild. Jorel Navarro says, this explains why Monica hasn't married him yet. RJ Zilla says, please tell me that Ty can get this to a judge and potentially a jury. Also, how will this play out in court? Thank you. You're a good man, senpai. Like I said, I've sent it all to Ty. I've sent all the stuff, including the stuff that I haven't shown yet to Ty. We'll see. I don't know if they can use it or not. That'll be up to them. They're deep in this. A2P says, sent Monica part of that doc on her Twitter. Lane 20 says, I guess Ron hasn't married Monica because he's learned that his evil deeds tend to come out on the record in divorce. Infernal Iris says, nah, I wouldn't forgive Funimation. Hey, Funimation, are you paying attention? Look what you've done to your fans. Look what you've done to the people who paid for your product. I wouldn't forgive Funimation if they had done proper investigation. Maybe this stuff would have come out sooner without costing Vic so much harm. Good point. Ninja Work 111, thanks for the donation. D-Man Dog 056 says, Bardock, now everything is going to change. Cody Byer says, of all the plot twists, I didn't see this coming. Me either, man. I had no idea. Ninja Work 111 says, the thought of the voice of Bulma being abused makes me want Vegeta to snap Ron's neck like a chicken bone in Minecraft. Please refund the last one. I can't. You've got to talk to YouTube. I don't know how to, I don't have any control. They don't send me emails. If I could go in and click refund, I would. I can't. Sorry. A couple people have asked when they make an accident. So, refund it with YouTube or whatever. Good luck. Godspeed. If they send me anything, I'll tell them to refund it in a heartbeat. Kalinka Pavlova says, I'm so effing furious. F you, Ronald Soye. Ben Frail says, pro tip, never threaten judges no matter what. Man. Loogie Head says, let's see who walks away a sex offender. Ron Toye says the woman beater. Projection much? Sounds like he's trying to deflect his evils. Well, what else is he guilty of? Lady Lavalin says, this man is literally the same guy who claims up and down that Vic has definitely got some buried skeletons in his closet. Only for us to find this out. Boy, only you have something to hide. Yeah, Ron. Kiesia Collins says, there's a reason Ron and Monica aren't married. Mad Chris 2449 says, I need a drink now. This type of stuff pisses me off so much it's just plain sick. Joel Navarro says, I really wish Twatter didn't lock my account over their vague BS terms of service. I'm missing out, but I will continue to flood them with appeals. I will not bend the knee. Patrick L says, recently found out that a former friend is a child enthusiast. Couldn't say the pedo word. Now this with Ron. I need a drink. Oh, sorry, man. E says, seems a reach for all to be Ron. Good bail excuse. Sapient Underground says, I appreciate the passion, but you seem to suddenly be leaning heavily toward it was all Ron solved. Is reality actually this convenient? Sometimes it literally is that simple, but I don't know. I'm not saying that's the case. Although, and maybe Lemoyne's got a conflict of interest here. It's certainly, I mean, in a real situation, this stuff comes up. You could easily throw the other defendants under the bus. The defendants in this case are not allies. They think they're allies. They're not actually allies. So, you know, they'll have to check that out. Blaine20 says, Sabat acts like an abuser. Just saying. Arius Metzer says, what if Soy and Sabat are the ones that colluded and forced others with violence? Sabat using Soy as muscle, as weird as that sounds. Is there a link? I don't know. Tracy Smith says, Vic would forgive them because he's a Christian. I think he would too. Austin Heartless said, Ron? No. I'm breaking my temporary no super chat rule. How did Ron think this wouldn't come out? I don't know. Of course it's going to come out. Cody Byers says, Ron, a smiley on Twitter so I don't hit her, Toye. Oh, God. Cody Bayer, sorry. Lane20 says, remanded to therapy for threatening to kill a judge? No way. Kalinka Pavlova says, press D in the chat for Dumbo Sharon. Shattercoin says, if Ron had court-mandated therapy, would the courts have records of that? I mean, they wouldn't have records of his therapy, necessarily, but they'd have records of the order. Indie Visualist says, rackets, let's get perspective. Sure, all this Toye stuff is bad, but Vic ate Jelly Bean. Wait. Golden Melody. Golden Melody says, first super chat ever. Hey, thanks. Had a bad night at work, so making your night good should balance things out. Thanks for all you do, Nick. You're a very good man. Hey, thank you. Sorry for your bad night at work, man. Or ma'am. It's kind of ambiguous from your anonymous screen name. Tomoki Sakurai says, would have loved what Masterson thoughts would have been. Kaki Onsai says, don't forget Dominique Sky, Jesse Pridemore, and all of the con-sluts defend Ron Toye. Every single one of them is guilty of enabling everyone. Emmett says, how did nobody find these court records sooner? They're hard to get. You have to go get them in person. Kalinka Pavlova says, hashtag wife beater Ron. Alex Bridden says, no more hashtag kick Vic. It's time for destroy a Toye. Lindsay B says, imagine how bad it had to be for his ex-wife to file an order of protection after he was remarried to someone else. Next victim. Wow. I don't know that that's what it was. I think his ex-wife filed this during the divorce. Kalinka Pavlova says, Twitch tonight, need a chill gaming stream. Oh, absolutely. Bad Vibe says, rackets drop Sar Bomba on Kick Vic. Enter the QB says, so Monica dated a pedo. Uh-oh. Sure did. And now she's engaged to a wife beater. Either she's just very unlucky or tasted men is suspect AF. Kalinka Pavlova says, if you support Ron, you're supporting domestic violence, just saying. She also says, law Twitter has each other's jizz in their ears. Richie Gonzalez says, Monica better make like Froppy and hop the hell out of there. Hippity hoppity, get off my froppity poppity property. I don't know. Yellow Jackets SA says, with Ron and Monica represented by the same counsel, could that be a method of control? It would be hard for Monica to independently seek a deal, wouldn't it, though? Wouldn't it? Bad Vibe says, take him to school, Nick. Sergeant McSalty says, and Ron's trending. Karma's a bitch, Soye. Nocturnus says, I just read a gotcha tweet favoring Ron, claiming that he was no longer beta because he can beat up women. Greg agreed. Like, really? Matthew Neidig says, glad for Lady Racket's sake, the vault is soundproof. You got veins popping out on you, Nick. Don't have an aneurysm on us. No, don't worry, buddy. No Clue says, Ron's abusive past puts so much into a new perspective. Remember when Monica made that strange flex about her supposedly amazing sex life with her sheepdog? Maybe he wrote that. Or maybe she wrote that to placate what would come if she didn't. Dark Knight says, T. Greg, I'm incompetent and I suck at being a lawyer. Douchebag POS is calling this stream is screeching on Twitter. To T. Douchebag, keep deflecting. Go away, Greg. No one cares. You're literally irrelevant. And your 38 likes on every tweet, have fun. Have fun with it. Unbeknownst X12 says, why is TCPA a thing that seems so outdated? It is outdated. It's a terrible law. It really is. Anti-slaps foreclose the ability of plaintiffs to bring a meritorious case, oftentimes. And they're not supposed to, but they do. They do. That's why they get overturned in some states like mine. Matt Field says, this shit is so hot, I have to use 2 devices to keep up. Twitter is on fire and Ron Soye is the fuel. Hashtag closeted skeletons kill sheepdogs. Jarrell Navarro says, Vic's victory song should be I'm Still Standing. Dragon Realm says, this just in, Ron Soye has privated his account and blocked a lot of people on I Stand With Vic. The cuck is hiding now. Why would that be, Ron? Raider J says, Ron said he was only in court for the mold case. Oh, did he? No, he did. I don't think he said only that. They just asked if he'd ever been deposed before. And I think he said for that case. No one important says, man, I missed a lot and this seems spicy. Gonna watch from the beginning. Here's money for me being shocked and impressed. Lady Lavalin says, come on, guys. As of right now, he's trending at 16. Let's get him in the top 10. Blaine20 says, this scoop counts as 2. Welcome to the club. Hashtag legitimate news outlet. Mr. DJ Flyhigh says, and now we see Shane's consent con die in the wind. Jay Prez says, on a related note, text connect to 741741 if you cannot make a call. It is the National Crisis Text Hotline. Nobody deserves that kind of life. Joshua Giddens says, you need to check out this Jared Genesis situation that's developed. EFAP used to cover him a lot. Turns out he's a total creep. Blaine20 says, Ron suddenly doesn't qualify to attend consent to con. Lol. Gawker's Death Rattle says, Ron abusive? Of course, the weak bully who they can. No one important says, pretty sure people as pathetic as Ron beat women because they can't take on any man. Blaine20 says, I'm glad this didn't drop during or before Bubba Fest. What a dark Paul that would have been. The Anime Collector says, if all this is true, I feel like there's a good chance that Toye trending on Twitter could get Monica killed. We should all be praying for her. Monica, get out. Get out. Dmitry Anikov says, you are all turning on someone accused by the same person who accused Vic. Are y'all retarded? Ron is an FAG, but he's still innocent before guilty. Innocent before guilty? Oh, Ron did this for sure. This is not a pretend matter. The court found that this happened. Let's be very clear on this. Ron went to a hearing with his ex-wife. They both told their story and the court found domestic violence had occurred. Period. End of story. This happened. They issued the protective order. They ordered him to stay a certain, we're going through all this over the next couple days. They ordered him to stay away from her house, from her place of work. They ordered no contact. They ordered no contact to the family. They ordered no harassment. They ordered no stalking. They ordered all of it. Everything she asked for, they ordered because they found that this happened. Innocent until proven guilty. He's guilty. He did this. He did this. The protective order was placed October 22nd or 24th. No, October 24th, 2012. And it would automatically expire October 23rd of 2014 because leap year, I believe, would cause it to, it would be 365 days times 2. That's kind of a standard for protective orders. And then you have to apply to get them renewed. I don't know if they renewed this. I doubt it. By that time, they were out of the relationship and probably didn't need the protection anymore. But no, this is not speculation. Bron Boa says, Ty, did you kick a hole in this wall? Shows photo of wall. Ron, looks like my wall. Joseph TX says, Roy, I think it's Ron, should go back to being a tow truck driver like he was in 2007. Joseph TX says, maybe this is why they kept spamming filings so we wouldn't look deeper. Destructicon Says, first time chat. Hey, thanks, buddy. Love the show. Kind of changed its perspective on Monica saying she wasn't going to Kamehacon for her safety. Kind of does, doesn't it? Lane 20 says, I need a drink. Kalinka Pavlova says, I need a drink too, but I have a zoo trip tomorrow. Blue Satoshi says, in before Twitter delist, hashtag Ron Toye from trending. Finally, we've got Schwazoom. How could Soye abuse Monica? She's twice his size. But seriously, is there a single one of them who isn't messed up? Sabbath's convention bans, Monica's dating pedophiles. Now this with Soye. What's next? Only time will tell. Marty Lund says, objection! Racket said legal drama was nothing like Phoenix Wright and then pulled a stunt like this. Also, if you have to get these docs in person, could you use an independent courier to confirm these docs? Oh, yeah. Yeah, you could. You just have to hire the person to go do it. So there you go. Dmitry Anikov says, my bad, haven't been keeping up for this month. No, that's fine. This all dropped today, and I haven't, I wasn't scolding you. I was clarifying because I haven't shown the other documents yet. I just had time for this one. The other documents I have to go through and redact them all. There's a lot of information on them that I cannot put out on my channel. Phone numbers, addresses, all that stuff. We don't want that. That's not the goal. I've got a lot of people's names who aren't involved in this. So I will be showing all of that. So as we go forward. So I didn't mean that to sound like a scold. I meant it just to clarify that there's more coming out that will solidify all of this. Lurik L says Rhino Milk. All right, thanks. Dorby says, Q, Mr. Toye, when did you stop beating your wife? Answer, I do not recall. Crackbot says this needs to be turned into a Lifetime movie now. Yellow Jagged SA says, lol, Ron is a prohibited person. I'm not, you're not. It's too bad. Too bad. Oh, and I am doing Twitch tonight. All right, guys. Okay, so my Stream Deck broke. This thing is weird. It was working just fine, and now it doesn't. Let me see if I can pull it up. But that's how I play my outro. I want my outro. Come on, Stream Deck, where are you? Where's the on button? Settings. Let's see if this works. Can we test it? If I could just test it, we'd be fine. It'd be great. All right, I'll have to do this in the annoying way. All right, give me just a second. We're gonna play the outro. Here we go. Here comes the... Oh, it's really loud. Hold on. Play. All right, there's the outro. The whiskey drinking lawyer is playing. It's still a little loud. I'll turn it down. Rando number 9 says, holy crap, Ron Toye is trending on Twitter. Joseph TX says, at least Ron is top 10 for once in his life. Iron Mater says, how many more new and interesting ways can we wipe our asses with the Constitution before it becomes socially acceptable to hold a woman accountable for her actions? I don't know. What are you talking about, pal? Kalinka Pavlova says, did you get more justice chats? I think I read them. All right, guys. We are done for the night. Yes, I will be on Twitch in just a few minutes. Just have to go to the bathroom and get some snack. There's no cucks in this house to bring me a snack tray. So we'll have to get the snack ourselves. If you want to come over on Twitch, come over on Twitch. Should be very chill. Last night I had some great runs on Risk of Rain. I think I'll probably do that again. We did Commando and Artificer, but I still got to get Rex. 'cause I still gotta knock the stupid hermit crabs off the freaking map. All right, guys. Thanks for hanging out tonight. It was a big night, heavy subject. We'll see. We'll see what happens over the next couple days, won't we? But Twitch link is in the description, along with all the other relevant links. Thanks, guys. I'll see you tomorrow. Peace. Peace.
They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed, so pour out a glass for the tea. Post on Twitter as we hear lawsplaining tonight. From the white shores of Nairn to the hills of Glen, living